Good morning, sir. Can you tell me your name?
Marquise Reed, sir.
Mr. Reed, you're here in case 2021 CF 6706AO on charge of criminal mischief of more, of $1,000 or more. This is a reset from yesterday for the state to provide additional information to the court as a probable cause. State has provided that information to the court. I am going to find probable cause for your arrest as to that charge. I'm going to stay your bond in the amount of $1,000. Condition your bond. Actually, say your bond amount of $1,000. Question, the cases that he's out on, that he's in on, are the possession of methamphetamine case,
Yes, the criminal mischief was an add-on charge.
and the possession of methamphetamine happened before, he was arrested before this case, so I'm just trying to make sure.
Yes, he was arrested before that.
All right. All right, sir, in 2021 CF 5939AO, the court's going to revoke those bonds set in those cases, going to set new bonds at $0, finding probable cause that you commit a new law offense while pretrial release had been ordered. Going to appoint the public defender to represent you in both matters.
Were they,
Not going to take any action on the 2021 MO 596AO case.
So sorry, you said that he was ordered on pretrial?
He's out on release. Pretrial release was ordered, not pretrial release supervision.
Oh, okay. Okay.
Cover your face, sir. All right, have a great day, sir. All right. All right. Got a quick question for you all, since everybody's here, before I start domestic violence here. Now, when I order, or Judge Gibson and I order, maintain a separate residence, what does that mean to you all? Yeah, because there seems to be a miscommunication of what we all think that means versus what's being instructed or the orders have been, well, I tell the defense in court, and then somebody downstairs is telling them something different. So I want to get a feel about what exactly that means to you all when we say maintain a separate residence. Right. Right. All right. So when they get the one-time return, they get to do that. They got to do that with law enforcement. They get to go back to the house. For instance, like the case that caused this confusion, I had a victim that testified that they were no longer at the residence. They had moved out. So then somebody told the defendant that they couldn't go back home, which seemed to be, all right. I was trying to figure out a way to get that communicated so everybody knows that. I'm trying, is there, so I'm saying, is there more than one system? Is there, so there's just one system? So there's a way to make notes in the system about what happened in court as to, right, but, so I guess our interpretation of that order is that it's on the defendant to maintain a separate residence. All right, so if it's their home, like we had a lady yesterday that was her house, that it's her house. I can't tell her, I can't violate her property rights in that way, without some kind of due process. So I'm trying to, so it's her house, but if I say maintain a separate residence and her living boyfriend was still at the house, then yeah, she gets there, dude's there, she has to go. But to say she just can't go back at all seems to be contrary to our orders. So if I say don't return, so there's a couple people yesterday that said, I don't care what's going on, you can't go back, period. So that's why we say then we should write no return on there, not just maintain a separate residence. Yeah. Correct. Yeah, no problem. I'm all about trying to be clear. So want to make sure we have great communication. I just want to make sure that when Judge Gibson and I or wherever is here, we're ordering maintain a separate residence, that doesn't mean that the person can't go back. It means that literally that they can't live together. So wherever this location was, as long as they're not living together, like some people come here on vacation, they're at an apartment, they're at a hotel room. I'm not telling them they can't go back to the hotel room, get their stuff. I'm telling them when they get back home to Virginia or wherever they are, or New York or wherever they come to visit us from, they can't live together there. They can't stay together at a hotel room while they're here in Florida. They can't live together. That's one of my intention of the order is. So I was trying to make sure that, is there a better way we can have that effective? Yeah. Yeah. No, I'm in agreement with that. I'm not, what I'm saying is that, like, for that instance, he was gonna take a legal action against the victim to eject him from the property or some kind of eviction process because she decided to let another adult live with her without a lease, which is unwise, but it happens. So if the victim's still there, if she goes home and says, and the victim's still there, she's gonna have to leave until she can get law enforcement and go get some temporary things until she can get in front of another county court judge to get him or her out of the property that belongs to her or him. Yes, ma'am. Yeah, correct. Go ahead.
Okay, so for, going forward, if a victim does testify and state that they moved out,
Right.
that the defendant can go back to the home, can we place that on the court order? Because we can't do anything if it's not on the court order.
That's what I mean. That's what I'm trying to figure out. Is there a better way for the order to be written? Is there a better way, because when I say maintain, like, so when you say maintain separate residence, like the defendant may return to the location as long as they maintain a separate residence. Is that a better way to write the order? I don't know how else to make a better standardized way of saying that than, that you all need to maintain a separate residence. Correct. 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 Yeah, that's what I said. But they need to turn on time with law enforcement. So the safe thing for them to do is to go there with law enforcement. You know what I'm saying? The reason, like, the problem with the order that happened to the one lady is because the victim already testified he wasn't there. So I didn't know, well, why did I give her, there's no purpose of giving her a one-time return. Yeah, the information the person's already gone. So I think the safe thing that usually I tell them to do, don't go back until you get in contact with law enforcement, do your one-time return, verify with pretrial release, I tell them to work with pretrial release, their attorney, verify that they, it's safe for them to go home without violating my orders. But it's ultimately up to them whether they're gonna say, they're gonna violate my orders or not. So, but I guess the problem then, because I don't want, the problem is I don't want the victim to put their address on the record. So that's what I'm saying. So because we said it's because the same problem. Yeah, but you guys are run into the same problem, because you say you can't put the same address in the system as a defendant, but you may not have another address because the victim just tells me they moved out, they're living with grandma or whoever, they're going to live with their sister, but I'm not gonna ask them to put an address on the record. So I just want to make sure that's not gonna also cause a conflict. All right. Yeah, okay. That works for me. Yeah. Right. All right. All right. Right. Yeah, usually I say that, but does that, clerks, when I'm putting somebody on pretrial, I'm putting somebody on pretrial release, that's out of state, do you write on the order that they may return to I usually say it, but is it written on the order? Yeah, return to wherever they go from. Yeah, okay. Yeah. All right. Is that including people on bond, or do you just want to talk about people that's on pretrial release? Yeah, correct, correct. Mhm. Yeah. All right. All right. So going forward, I say maintain a separate residence. You have evidence that the person does not live at the residence. I guess, what's languages you guys want to use from, at that point? Madam Clerk, you okay with that? Yeah, right. So make sure we're not, redoing things, because that's why, that's one of my things. I don't like to redo stuff, like if I can avoid it. I think the concern is, from them, is that the person is going to just go to the residence because nobody said that they can go back. But it kind of, in my mind, logically makes sense that if I live with my girlfriend and we live together, that if I need to say to maintain the rest of residence, I need to go somewhere else. If I have a girlfriend and we don't live together, we just share, that's just my baby mama or whatever, or my ex-wife, I'm never going back to her house because we don't live together. That is, I can't go because, which makes sense, because the no contact order already covers that. You can't be within the 500 feet of the person's residence, which already covers that portion of that situation, because you guys can't reside together, you can't be within 500 feet of the residence. Yeah. Yeah. Yeah, we'll continue to do that. We'll just notate for them that, there was evidence that, a lot of times law enforcement puts the victim's address as the defendant's address, which usually sometimes, a lot of times, is not true. They usually don't live together. So, it's like, it's 50% of the time it's not true. So for them, the problem is that when they got downstairs, they see victim lives here and defendant lives here. So obviously he can't go back there because it's a maintained separate residence. But if the victims give information to us, that they moved out, then, that'll change that, obviously change that for them. We'll get it done. The only thing we can add is, as I'm saying, trying to add that victims testified they moved out. It's in the little thing at the bottom of the order. No, so I'm saying, if the victim, we have information. This is victim testifying, victim, we have new information in court that's different than the information that they get in the packet. So we're trying to note to make sure, notation that the information is different. Yes, ma'am. Go ahead. Yes. Yes, ma'am.
Maintaining.
You can start it as soon as you see them. The first check-in with them, usually we order that they're having a grace period for the narcotics. So, if you, because usually the maximum time that like cannabis can stay in your system is 30 days. So I'm not gonna pop you for smoking, days or weeks before you got arrested, and now you show up at a drug test and now you test positive because you still got technically THC in your system, even though it may be a low, concentrate. But, a lot of those other drugs, cocaine doesn't stay in your system that long. Methamphetamine doesn't stay in your system that long. So if you get popped for that, then, that's usually the intention. Our intention is that. So, but, most of the time in the DV cases, it's usually alcohol related. So we'll make sure that, you're not adding an aggravator to the situation by you drinking, and make you not, do something that's going to make you regret that. Right. Yeah. Mm. Yeah. Oh yeah, usually I order that you be drug tested at your own expense. So that's how I order it. See. I don't think that's even, is that an option for the order? I don't think that's an option for the order. I think the order just says, that's the question I had when this initially popped up, was that my thoughts were that the person was being referred to a Quest or wherever to be drug tested, and then that report needed to be sent to here. So that's what for the people, no, for the people that are now on supervision. So people that are not on PTR, when I ordered drug testing, my thought was that they're out of state. They get to go to whatever you or arrange at some lab you ordered them to report to, and then that person, they have to send that lab report, gets sent to you. They have to pay for that. Yeah, that's my thought, my process during that. So I don't know if that was a possibility. Yeah. Right. Right. Okay. Yeah, just let us know. I don't think the order, as I said, once again, I don't think the order says, it just says random drug testing. I don't think the order actually says random drug testing through PTR. So. I just want to look at the box. Correct. Yeah, that's what I was saying. That was my thought was, can we do that? I don't do it anymore, but my thought was when I was doing it was that that's the process that was being, that you were supervising it that way. They're not coming to PTR. They're not showing up here. They're going to whatever drug testing site that you tell them to, you order them to report to, and completing the drug test, the report's being sent to the court, and, you know, or to you all, and then, you know, if something comes awry, then it requires me to take action, then I will, was my thought process in the situation. I don't know if that's a possibility, let me know, and then, you know, we can, you know, possibly make that a change that we can talk about with the order. Yeah. All right. All right, appreciate you all showing up, thank you.
PTR.
Welcome to an Econo meeting. You are entering the meeting now.
Granger, please.
You'll probably do 250 or probably.
Good morning, Mr. Cohen.
Good morning, Judge.
Are you representing Mr. Granger?
My office, Melissa Vickers of my office is attorney of record.
Okay.
I'll probably do a bond similar to that.
There it is. Good morning, sir. Can you tell me your name?
Joshua Granger.
Mr. Granger, you're here this morning in case 2021 CF 1120 on the charges of burglary of a dwelling with assault, battery therein, domestic violence, aggravated assault with a firearm, domestic violence, written threats to kill, do bodily harm, extortion with a weapon, and petty theft. The judge signing your warrant in this case has found probable cause for your arrest as to those charges.
Your Honor, we have already filed an information with different charges.
You got a copy of it?
I have a copy of the first page. May I approach?
Mr. Cohen, do you have a copy of the information, or did you pull it
I
up?
do not.
All right. All right.
Actually, you know what? I apologize, Judge. I do have that.
Okay. All right, so count one is burglary of a dwelling with assault, battery therein, domestic violence. Count two is extortion with a weapon. Count three is written threats to kill, do bodily harm. Count four is aggravated assault with a deadly weapon. Count five is domestic battery by strangulation, and count six is petty theft. So there's 6 counts, and we got, won't give them bonds on all the counts, so we got to do a new order probably. All right, State, what do you ask me to do as to count one of the information?
Your Honor, as to count one being a punishable by life offense, state is asking that you hold him no bond pending an Arthur hearing downtown.
Right. And Mr. Cohen, are you making any argument as to that request?
Judge, I would argue that I don't know if the state has filed a motion for pretrial detention pursuant to 3.132.
Well, it's a punishable life offense, so the question is, are you asking for Arthur hearing now, or are you asking for Arthur hearing later? Are you reserving that right?
Judge, we'll reserve the right. That way we'll go in front of Judge Blackman downtown.
All right. All right, so Mr. Granger, at this time, the court, in count one, the court's going to hold you at no bond. Count two, going to stay your bond, and going to set your bond amount of $2,500. Count three, going to set your bond amount of $3,000. Count four, going to set your bond amount of $2,500. Count five, going to set your bond amount of $2,500. And count six, going to stay your bond amount of $300. It's the petty theft charge is $300. Condition of those bonds is you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You have Mr. Cohen and Mr. Cohen's office representing you, and I believe Ms. Melissa Vickers is your attorney of record. I want to strike the no return to the scene. It's on the warrant. It's on the warrant, so I'll strike it. And then as to case 2019 CF 13627 AO, you're out on bond on that case when this case happened. The court found a probable cause and the warrant being signed where the judges found probable cause for your arrest as to that charge. The court's going to revoke that bond. I'll say a new bond is $0. Is Ms. Vickers representing him on that case as well, Mr. Cohen?
We are, Judge. Would the court consider just setting a new bond on that case? He's been out on bond for almost 3 years without any incidents.
Well, based on the facts and alleged in this affidavit, this warrant affidavit, the court doesn't feel comfortable setting the bond at this time. Obviously, those are things you're going to address with Judge Blackman downtown
Understand.
when you see him.
Understand, Judge. Thank you.
All right. Have a great day, sir. Have a great day, Mr. Cohen.
Judge.
Mr. Lefford, what case do you have? So I can get it pulled up.
Good morning, Judge. I've got Juan Lucian, here.
Interpreter case?
Bottom of the interp docket.
Am I ready to start interpreters yet?
We still have 3 more.
All right, let me get the move ups done and then I'll jump in. I'll get to do all my interpreters in one foul swoop.
Sure, no problem.
Thank you. All right, good morning, sir. Can you tell me your name?
Charles Anthony Jackson.
Mr. Jackson, you are here this morning in case 2021 CT 549AE on charge of driving under the influence. You're here for arraignment this morning. You're represented by the Public Defender's Office. You want to enter a plea on behalf of your client, Ms. George?
Yes, Your Honor, I'll enter a plea of not guilty.
The court accepts your plea of not guilty, sir, and sets you for Division 63 for pretrial conference and trial.
Pretrial conference will be July 1st at 1 p.m., courtroom 12C.
All right, I apologize, sir. You also had 2021 CT 550AE for refusal to submit to a blood or breath test. You also represented by the Public Defender's Office in that case.
Yes, Your Honor, I'll enter a plea of not guilty.
Same date, July 1st, 1 p.m., courtroom 12C.
All right, have a great day, sir. Good morning, ma'am. Can you tell me your name?
Sir.
Can you tell me your name?
My name is Milagros Mercado, aka Mildred Guadalupe.
Right.
Birth and marriage.
Ma'am, you are here this morning in case 2021 MM 3517 AO for arraignment this morning. You're here for a charge of trespass on property other than a structure or conveyance.
Yes,
That is a
sir.
first-degree misdemeanor. It's punishable to 1 year in the county jail and $1,000 fine.
Sir, can I explain?
Ms. George represents you from the Public Defender's Office. Ms. George, is there a plea you want to enter on behalf of your client?
Yes, Your Honor, there's an offer of an adjudication of guilt, credit time served, no return.
Abide by the trespass warning.
Oh, okay.
Cost of investigation of $60.58 to OPD.
All right, Your Honor, we would like to accept the state's offer and enter a plea of no contest.
Okay. Ms. Mildred, Ms. Mercado, can you raise your right hand and be sworn in?
Yes, sir.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You put your hand down, ma'am. Ma'am, we're here in case 2021 MM 3517 AO on a charge of trespass on property after warning. That's a first-degree misdemeanor. It's punishable to 1 year in the county jail and $1,000 fine. Do you understand that?
Yes, sir.
Ms. George is telling me that you want to enter a plea of no contest in this case. Is that correct?
Yes, sir.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on that plea form that's in front of you?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
What is that mental health illness?
Bipolar disorder, sir.
Are you suffering from any of the symptoms of your bipolar disorder right now?
At this moment, no.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir, myself.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
I'm an American citizen, sir.
Does the party stipulate to a factual basis?
Yes, Your Honor, for the purposes of the plea.
Yes, Your Honor.
Based on a stipulation, Ms. Mercado, the court's going to accept your plea in this case. When it accepts your plea of no contest, finding that the plea is freely and voluntarily entered, I'm going to adjudicate you guilty of the charge. I'll give you credit for the 17 days that you spent in the Orange County Jail with 17 days credit time served. The court costs and cost of prosecution in this case are $273. There's a $50 public defender application fee and a $50 public defender lien. There's also $60.58 to cost of investigation to Orlando Police Department.
Yes, sir.
I make all these costs payable directly to the clerk within 3 years of today's date.
No problem, sir.
You have 30 days from today's date to appeal your judgment, sentence, in writing. Do you understand that?
Yes, sir.
All right. You have a great day, man. Good morning, sir. Can you tell me your name?
My name's Kirk Lawrence Triplett Jr.
Mrs. Tripoli, you're here in case 2021 MM 3064AO on charges on a charge of possession of drug paraphernalia. That's a first degree misdemeanor. It's punishable to 1 year in the county jail and a $1,000 fine each.
Your Honor, state announces a null pros.
All right, Mr. Tripoli, the state of Florida dismisses charges against you. So have a great day, sir.
I've already filed that null pros with the clerk.
All right, the last one is Alice. I have Alice,
Alcia
Celia?
and Lacerna are both Spanish interpreter cases.
but you have Mr. Lacerna. All right. Let's get somebody.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today, Your Honor.
Good morning, Mr. Romero. This is Judge Bain calling from the BRC. I have a couple of defendants this morning I need your help with. The first one has the headsets on. Can you see if you can make a connection? So you need an interpreter.
Yes.
Sir, do you need an interpreter?
Sí, necesito intérprete.
Yes, I need an interpreter.
Sorry, Madam Interpreter. I was speaking to the victim that was in the booth. I was trying to see if he needed your services as well.
Ok. Señor, la víctima, ¿usted también necesita intérprete?
He said no. Yes.
Sí.
Yeah, he said shaking his head no.
Ok,
So we
thank you.
can stick with the headsets. All right.
Thank you.
Good morning, sir. Can you tell me your name?
Buenos días, señor. Mi nombre es Juan Manuel Lacerna Aguirre.
Good morning, my name is Juan Manuel Lacerna Aguirre.
Sir, you're here in case 2021 CF 6799AO on charges of tampering with a witness to hinder communication and battery domestic violence.
I'm sorry, Your Honor, I'm getting a really bad echo. Can you repeat that for the interpreter, please?
Sir, you're here in case 2021 CF 6799AO on charges of tampering with a witness to hinder communication with law enforcement and battery domestic violence. I reviewed the charging affidavit in this case. They find probable cause for your arrest. Sir, can you tell me your name? Can you tell me your name and spell your last name?
Manuel Lacerna, Lacerna.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Put your hand up. Can you tell me how you know Mr. Leonardo Aguirre?
How I know who?
How do you know the defendant?
My father.
How do you know the defendant?
Who's the defendant?
He said it's his father.
What?
He said it's his father.
Okay. Do you want to have contact with your father while this case is pending?
Yes.
Your
Are
Honor,
you,
Mr. Lucerna is not the intended victim of
That's
the
what I
charges. I believe he was just a witness.
all right. All right. Sir, do you want to tell me anything about your dad's release before I set release conditions?
No.
Say again?
No.
Okay.
Police
So
are
that-
just waiting outside, Your Honor, just give you some information, and they let the son in. So, because he was a witness, the whole family came, and because he was actually a witness, they know he doesn't know what he's doing here.
Okay.
Yeah.
All right. Well, Mr. Lefford, is something you want to tell me before I set this case?
Yes, Your Honor, just real briefly, client qualifies for PTR. He has stable employment and no criminal history. The victim has indicated in the affidavit doesn't want to prosecute and file a declaration. That being said, Mr. Lucerna did plan a trip to Peru. He was actually supposed to leave yesterday. My understanding with PTR is that an individual can leave. Is that correct?
All right, I'll say it again.
I'm sorry, counsel. Can you repeat that for the interpreter?
Can an individual leave the state of Florida on PTR?
I have to have an address. I can authorize pretrial release out of state. They need to provide
For a
location.
trip, Your Honor, just for a trip to Peru that he had planned with the son.
That's something you have to take up with, I don't know who the division judge here is. I was usually make you file travel plans,
Yes, Your Honor.
tickets and things like that when you're coming, when you're going.
Mr. Lucerna was supposed to leave yesterday, so he's planning to leave this week. So that's why I brought it up with Your Honor.
All right.
It's an
I'm
important
not really equipped to handle that right now, especially since the witness I have isn't the victim. So, obviously, we need to talk to, I don't know, who's the division judge? Yeah, talk to Judge Roach and, get a motion filed with tickets, return dates, all this kind of stuff like that. Usually, that's not a problem.
Sure.
All right. This one, as to count one of the charging affidavit, I want to set your bond in the amount of $1,000. Count two would be $500. Be subject to pretrial release supervision. You had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return to the residence to retrieve any personal items you have in the location. You may not possess any weapons or firearms. The weapons and firearms you have need to be returned to law enforcement within 24 hours of your release. You have Mr. Left representing you as counsel. So have a great day, sir. Good morning, sir. Can you tell me your name?
Carmelo Marrero Figueroa.
Oh, the one case.
Is it from the felony section?
Yeah, it was a cannabis drug, possession of cannabis. Sir, tell me your name one more time.
Carmelo Marrero Figueroa.
Carmelo Marrero Figueroa.
No, I gave you one felony case, possession of cannabis. Yeah, Matthew Santana is the one felony case I have. I gotta find, well, let's look, we can find Mr. Figueroa. at all? Yeah. Representative Mr. Santana? All right, do you want to do him next? Yeah, he should be back there. All right. All right. Good morning, sir. Can you tell me your name?
Bernardo Alicea. Bernardo Alicea.
Bernardo Alicea.
Mr. Alicea, you are here this morning in case 2021 CF 6791AO on charges of aggravated assault with a deadly weapon, domestic violence. They reviewed the charging affidavit in this case, identifying probable cause for your arrest. Going to set your bond in this case amount of $2,000 and subject to pretrial release supervision. As you have no contact with the victim in this case. I need you to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case, sir.
I would just ask, would you consider lowering the bond? I don't see any type of violent history. And based on the facts of the case, it seems that there may be some mental health history, and then it doesn't appear that he chased after the son. So it does not seem like his normal behavior. I would just ask that you consider lowering the $2,000 bond, being that he is going to be on pretrial release as a non-violent history.
I already did that. The standard bonds, I think, is around $3,500 for an aggravated assault. So I already dropped it down. So say you're bonding around $2,000. Does he have a medical? Does he have like a doctor's appointment he needs to go get to for mental health?
Your Honor, I don't speak Spanish, but when reviewing the,
Yeah.
he said yes.
Yes.
All right.
Yes.
Sir, I'm also going to order that you maintain all your mental health doctor's appointments, that you take all your medications that you're prescribed in the doses that you're being prescribed them, okay? If you need some assistance, you should reach out to that number on the green sheet of paper, talk to your attorney, and we can get some resources in your direction.
I have a one long. I have a one long.
You have one lung? Okay, sir.
Yes.
All right. Well, have a great day, sir.
How much is the bond?
Bond is $2,000.
Do we have another case for Spanish, Your Honor?
I believe so. We're trying to get Mr. Santana,
Okay.
locate him and get him in the courtroom. He's on his way, Your Honor. On
No
his way
problem.
from, do I need to let the interpreter go? Or how long is it going to take for him to get here? Does not need an interpreter, correct? All right. Thank you, Madam Interpreter.
You're welcome, Your Honor. Just call us back if you need us.
Yes, ma'am.
Thank you.
All right. Where did this come from? So, we didn't get a case. I didn't even see this case. All right. Next person I have is Francis. All right. Good morning, sir. Can you tell me your name?
Good morning. It's Darian Francis.
Mr. Francis, you're here this morning in case 2021 CF 6745AO on charge of battery, domestic violence by strangulation. Review the charging affidavit in this case. If I'm probable cause for your arrest, I'm going to set your bond in this case to the amount of $3,500, condition with subject to pretrial release supervision. You'd had no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at a shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case, sir. You have a great day.
Your Honor, was that 25 or 3,500?
3,500.
30? Okay, thank you.
This is Mr. Mathis. Going to appoint the public defender to represent him. We're going to reset him 24 hours from release from the hospital. Good morning, sir. Hello. Good morning. Can you tell me your name, sir?
Alexis Ramos.
Mr. Ramos, you are here in case 2021 CF 6787AO on charge of aggravated battery, domestic violence. Reviewed the charging affidavit in this case, found probable cause for battery by strangulation. That's Florida statute 784.041 sub 2 sub A.
Your Honor, I believe that's what the officer intended
Yep.
due to his affidavit.
Good morning, ma'am. Can you tell me your name and spell your last name?
Yes, Stephanie Ramos, Ramos.
All right. Can you cover your face for me?
Yes.
Thank you. Can you raise your right hand as best you can? One of you switch the baby. There you go. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You put your hand down, ma'am. Can you tell me how you know Mr. Ramos?
He is my husband.
All right. And do you want to have contact with your husband while this case is pending?
I actually want to drop all charges.
Well, it's not on you to whether this charges will be dropped or not. It's on the state of Florida. So my questions have to do with release conditions. So do you want to have contact with your husband while the case is pending?
Yes, I want contact with my husband.
Are you afraid of him?
No,
Has there been any prior instances of domestic violence between you two?
no,
Where did drugs and alcohol play a role in this incident?
no,
If something like this were to happen in the future, do you feel comfortable contacting law enforcement?
no.
All right, you gotta cover your face for me, man.
Sorry.
All right. All right, Mr. Ramos, in this case, the court's gonna set your bond, in this case, an amount of $3,500. You're gonna condition your bond that you had no contact with the victim in this case, that you maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess or consume any drugs or alcohol without a valid prescription. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Is this the father of this child?
Yes,
Did he sign the birth certificate?
yes,
Were you all married while this child was born? All right, Mr. Ramos, part of your release in this case, you must keep maintaining support for this child financially. So if you guys have a shared bank account, you guys still make those deposits. Make sure this child has what they need. You understand that?
Sir.
I'm so sorry. Would he be coming home today?
No, ma'am.
So how could, I just have to pay the bail?
You can pay the bill if you like. He still can't have any contact with you.
So, because he has to come home.
He does not have to come home because I'm ordering him not to. If he comes home, and somebody sees him at home, or he commits contact with law enforcement, they will arrest him. He will spend the remainder of his time here with me at the Orange County Jail on a no bond status.
And
So
what
don't encourage him to violate my orders. My concern with you is that you told me that you don't want to call law enforcement. When I read the incidents that happened in this case, where most strangulations that happen and most domestic violence murders or homicides happen by somebody getting strangled or choked in the manner of which was described in that affidavit. So I'm not confident that you're able to protect yourself from him in this case.
Your Honor, I'm not sure she understood the question that you asked.
Do you feel comfortable contacting law enforcement if incidents like this happens again? She clearly told me no.
Well, this question normally trips up alleged victims. I do not believe she understood what you were asking her. So I would just ask that it is asked again so that she understands the question, Your Honor.
No, ma'am. I think she answered my question truthfully. She felt like that she wanted this case dropped, that she didn't want to.
Excuse me, Judge Andrew, I'm gonna be completely honest with you. We don't know, I don't know how the state works, neither does he. I just wanna know what's the next step for my family could be together again. Because I didn't even know he was gonna get arrested yesterday until after. That wasn't even the plan. That wasn't.
Well, in this state, in pretty much every state that I know of, in our United States, in our union, works all the same way as for domestic violence. It's about the same
I was
everywhere.
told, I'm so sorry, I'm not trying to go over your head, but I was told different. And I'm just, if you could just point me in the right direction, how can I get my family together again?
Well,
I would highly appreciate that as a human.
you need to speak to the state of Florida because they're the ones in charge of charging your husband with a charge if they're going to do that. I'm not sure they're going to do that. I don't control that. All I control is whether I find probable cause for the affidavit that I have in front of me and set appropriate release conditions based on those affidavits.
Okay.
That's the only thing I do at this jail. But after this happens, he's going to get a division judge. What division is he in front of? You're in front of Judge Patricia Showbridge. That's his judge for the sign to his case. And when the state of Florida makes a charging decision, you'll have more court dates.
So would he be coming out at all today?
I don't know. Mr. Ramos can bond himself, or you can post his bond. He just can't have any contact with you.
Well, that's my husband at the end of the day.
I understand that, but you understand me. He's going to suffer the consequences of you doing whatever you want to do. It's not going to be him. It's not going to be you.
So I will leave the house and he could stay with the house. I have mutual family here. So as long as he has a place to stay, I don't care.
Okay. All right. And then are you moving? You said you're moving out today?
Yes, I could bail him out right now.
Yep. But are you leaving the house today?
Yes.
All right. So let's get some of these cases. Can you make the note on the order? All right.
So, all right. And I just go next door just to bail him out?
Yep, you can post his bond, you go to the bondsman, that's outside of my control, how you decide to get his bond.
And once I pay that, he'll be out probably later on today?
However long it takes him to process out.
Okay, thank you.
All right. All right. Good morning, sir. Can you tell me your name?
Matthew Santana.
Mr. Santana, you're here in case 2021 CF 6778 AO on charges of possession of cannabis with intent to sell and deliver and possession of cannabis of more than 20 grams. I reviewed the charging affidavit in this case. Did find probable cause for count 2, unless the state has more information as to count 1.
No, Your Honor, I don't believe there's any scales or any other paraphernalia that would show the intent to sell or deliver, so state has no objection.
So, sir, as to count 1, I'm going to ROR you as to that count. Count 2, going to set your bond amount of $1,000. Condition of your bond is you're not allowed to possess, ink, or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. You are out on bond. In case 2020 CF 1442 AO. Sorry, Mr. Leopard, put your name on the record. I apologize.
Joe Leopard on behalf of Mr. Santana.
As to that case, just say you charge is 2 counts of grand theft and 2 counts of unlawful possession of or a credit card.
We charge 2 counts of grand theft, 2 counts of unlawful possession of a stolen credit or debit card, and 2 counts of use of credit card of another.
All right. All right, so I'm going to revoke those bonds in that case. Going to set new bonds in your cases. And counts 1 and 2, going to set them an amount of $5,000 on each count. Count 3 and 4, going to set them an amount of $2,000 on each count. And count 5 and 6, the court's going to set your bond amount of $1,000 on each count. Condition of those bonds that you have no contact with the victims in those cases. That you do not possess any personal identification except your own. You understand that?
Right.
Mr. Leopard, you representing him on the other case as well?
Yes, Your Honor.
Yes.
So you have representation on both your cases? You have a great day, sir.
Yes, Your Honor. Thank you, Judge.
All right.
Have a good one.
Good morning, ma'am. Can you tell me your name? Ma'am, you're here in case 2021 CF 6697AO on charges of battery by strangulation, domestic violence. The judge signing your warrant in this case did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name? Cover your face.
Sasha Williams, Williams.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down, ma'am. Can you tell me how you know Ms. Rubin?
My girlfriend.
All right. And do you want to have contact with her while this case is pending?
Yes.
Are you afraid of her?
No.
Has there been any prior instances of domestic violence between you all in the past?
No.
Did drugs and alcohol play a role in this incident?
No.
State, can you tell me about these prior DV cases? And Ms. Williams, got another question for you. Are you aware of Ms. Rubin's prior domestic violence cases? What's so-so?
I guess. I don't know her
Say again?
ex-girlfriends. I don't know them.
I don't know. It's an interesting question because, you know, it's somebody you dating. Just thoughts?
Your Honor, at least in Orange County, I have a 2008 misdemeanor non-arrest BAT DV with a different victim. I have a 2007 misdemeanor BAT DV and criminal mischief, also a different victim.
Well, I'm more concerned about where this, I see a prior felony battery, domestic violence by strangulation. Is that out of county?
You said what?
I don't see it here in Orange
There's
County.
a prior arrest for this the exact charge. So that's what I'm trying to figure out.
I don't see it in Orange County. I'm gonna check CCIS.
I was ruling this case. I want to set your bond in the amount of $3,500. Condition of your bond that you had no contact with the victim in this case. That you need to maintain a separate residence from this victim. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at this location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case.
I don't see it in the state of Florida, Your Honor. I believe it may be from New York.
All right. You're out on bond in 2020 CT 8108AO. I'm not going to take any action on that case. You have a great day, ma'am. Good morning, ma'am. Can you tell me your name?
Gordon Smith.
Ms. Smith, you are here this morning in case 2021 CF 6767AO on charge of aggravated assault and battery domestic violence. The judge signed your warrant in those cases, found probable cause for your arrest. You're going to set your bond at count 1 in the amount of $5,000, count 2, $1,000. Condition of your bond that you had no contact with the victim in these cases, that you maintain a separate residence from these victims. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at the shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in that case. You have a failure to appear warrant in 2018 CF 15917AO. The judge initially set your bond at $5,000. I'm going to strike that bond. I'm going to set a new bond at $0. Ma'am, you are a violent felony offender of special concern. You're not going to be entitled to release on that violation of probation case until your violation of probation is completed. You have a great day, ma'am.
Do I have questions?
Say again?
Do I have questions?
You have a question?
Yes.
Ms. George, can you answer Ms. Smith's question? Good morning, sir. Can you tell me your name?
Morning. Anthony Stavallo.
Mr. Stavallo, you're here in case 2021 CF 6795AO on charges of battery domestic violence by strangulation and battery domestic violence. This is a warrant. I did review the charging affidavit in this case. I did find probable cause for your arrest. Ma'am, can you tell me your name and spell your last name?
Tasia Lord, Lord.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You put your hand down, ma'am. Can you tell me how you know Mr. Stavallo?
He's my ex-boyfriend.
I can't hear you.
He's my ex-boyfriend.
And do you want to have contact with Mr. Stavallo while this case is pending?
Sure.
But sure.
Yes.
All right. Are you afraid of him?
No.
Has there been any prior instances of domestic violence between you all in the past?
Yes.
Would you have maybe the subject of these prior cases I'm looking at right now for aggravated assault and aggravated battery?
No.
Did drugs or alcohol play a role in this incident?
No.
All right, Sorry, State, you have any questions for the witness?
No, Your Honor.
And Ms. George?
No, Your Honor.
Mr. Zavala, in this case, in count 1 was such a bond amount of $3,000, count 2, $500. Both those bonds be subject to pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release.
Yeah, excuse me.
You want to appoint the public defender to represent you in this case?
It's actually his house. Could I just get my stuff from his house?
Yep. So are you leaving today?
Yeah, I just want to get all my stuff out and just leave and be done.
All right, well, you hustle on over there because it's going to take you a couple hours before he's released.
Okay.
Get that done. I guess it's another situation here.
Okay.
Are we gonna
She's saying she's not living there, so you can go home.
strike the one-time return?
I'll strike the one-time return. I mean,
If he's gonna go back to his place and live, they're gonna take it as a one-time return. Why? You get what I'm saying?
I understand. That was my interpretation of the problem the last time. It was yesterday. And that's why I said, what can we do to make it better? Because I thought I was clear, but apparently I wasn't. So I mean, apparently somebody took my orders differently than what I intended them to be taken, so I'm just trying to figure out a way to make it better.
Oh, I didn't know anything about that, but I'm just like,
Yeah, because last time, what happened last time was that I ordered them to maintain a separate residence.
mhm.
Because the victim came in and testified, just like Ms. Laura did, that she wasn't gonna be living at he wasn't gonna be living at the residence anymore, that he had moved out. I did not give a one-time return, and they told the person they couldn't go home. So I'm trying to avoid that situation from happening again. So whatever I can do to make sure that doesn't happen, so that Mr. Zavala can get back to his house
Okay.
and maintain and abide by my orders without him getting arrested is what my goal is. All right? So my goal is, if you can go back home, if she's not there, Ms. Laura moved out, went back to where we're going, wherever she's going, you can go back home. You guys can't have any contact with each other. But for some reason, she hasn't finished moving out. When you get home, you're gonna have to hightail it out of there because somebody sees you, so law enforcement comes in contact with you, you're gonna get arrested. All right? So you need to make sure you're not having contact with her. You understand that? My goal is that you're allowed to go home, but it's to maintain, you guys can't live together.
Well, we can't live together, but did she just say that?
No, that's why I'm trying to, we had an issue the other day that caused a little bit of a problem. I'm trying to avoid that issue, to make sure my order is clear that Ms. Lord is not going to be living at the residence and she's going to be living somewhere else so you can return home. Because I don't want somebody to go downstairs and tell you that you can't go home when I'm telling you right now you can go home.
Yes, sir.
On the other things, you may want to address some of these other issues while you're seeing us so frequently with similar charges. So you may want to look at, treatment options, something else, other than coming to visit us.
So how would I go about the no contact? She's saying that.
No contact. She's going back to wherever the house is or apartment, moving out. So as long as you're not having contact with her, no social media, no everything on that order. No social media, no phone, no in person, no billboards, no carrier pigeons, no writing letters in the sky, no nothing, zero contact.
The whole case?
I was gonna order this. Okay. The whole case. Because it calls.
Sir.
All right, everybody have a great day. Can you tell me, good morning, ma'am. Can you tell me your name?
Kano.
Ms. Kano, you are here in case 2021 MM 3933 AO on charges of battery, domestic violence. I did review the charging affidavit. In this case, I did find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
George Groth, Groth.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, put your hand down, sir. Sir, you're here in case, I'm sorry. Can you tell me how you know Mr. Kano, Ms. Kano?
She's my girlfriend.
And do you want to have contact with her while this case is pending?
Yes.
Are you afraid of her?
No.
Has there been any prior instances of domestic violence between you all in the past?
No.
Were you the subject of this battery domestic violence arrest in her, I see in her history? She has a prior domestic violence battery arrest. Were you the subject of the victim in that case?
No.
It was a different victim, yeah.
That's one. Do you want to have did drugs and alcohol play a role in this incident?
Yes, alcohol.
Ms. Davis, why didn't she qualify?
I gave you an updated sheet.
Oh, okay. All right. All right, Ms. Kane, I'm going to set your bond in this case in the amount of $1,000 is going to cover pretrial release supervision. That you have no hostile contact with the victim in this case. Now, no hostile contact means this. You can be upset with him. You can be upset that he's not treating you the way that you want to be treated. He left the toilet seat up, left a mess in the kitchen and didn't clean it up. All those things, well, they're normal things that happen in a relationship. However, those disagreements cannot turn violent. They cannot turn threatening. They cannot come to the point where he's going to call law enforcement or somebody that sees or hears you all arguing is going to call law enforcement. Because if that happens, you will be arrested. You'll spend the remaining of your time here with me at the Orange County Jail. Do you understand that?
Yes.
I can't hear you.
Yes, you do.
You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you in this case. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Good morning. My name is Mark Joseph.
Mr. Joseph, you're here this morning in case 2021 MM3920AO on charges of battery domestic violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. Ma'am, can you tell me your name and spell your last name?
Yes, sir. Candace Reddick. Reddick, Reddick.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Can you tell me how you know Mr. Joseph?
He's my boyfriend and the father of my child.
And do you want to have contact with him while this case is pending?
Yes, sir.
Are you afraid of him?
No.
Has there been any prior instances of domestic violence between you all in the past?
No, sir.
Did drugs or alcohol play a role in this incident?
No.
If something like this were to happen in the future, do you feel comfortable contacting law enforcement?
Yes, sir.
And for this child, did he sign a birth certificate or has there been a legal determination that he is the father?
Yes, he signed the birth certificate.
All right, Mr. Joseph, I'm going to set your bond in this case in an amount of $500. It's going to come with pretrial release supervision. You are to have no hostile contact with the victim in this case. No hostile contact means this. She's allowed to be upset with her. You're allowed to be upset with her. She's allowed to be upset with you, and vice versa. You all argue about things that normally come up, finances, who's going to take care of the baby, all those kind of things like that. However, those disagreements cannot turn violent. They cannot turn threatening. They cannot come to the point where she's going to call law enforcement or somebody that sees or hears you all arguing is going to call law enforcement. Because if that happens, you will be arrested. You spend the remaining of your time here with me at the Orange County Jail. Do you understand that?
Yes. Yeah.
You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You understand that?
No, I don't got no firearm.
I'm telling you, do you understand that if you have any weapons or firearms, they need to be returned to law enforcement?
Yeah.
All right. I'm going to appoint the public defender to represent you in this case. You have a great day, sir. Good morning, sir. Can you tell me your name?
Good morning, Your Honor. My name is Wesley Mitchell.
Mr. Mitchell, you're here in case 2021 MM3921AO on charge of battery domestic violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. Going to set your bond in this case at the amount of $1,500. Condition of your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. You be subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you in this matter. You are out on bond in case 2021 CF 6508AO. The court is going to revoke that bond. We're going to set a new bond in the amount of $5,000. Condition of that bond that you not possess or consume any drugs or alcohol without a valid prescription. You'll also be subject to random drug and alcohol testing in that case. I believe you already had a public defender in that case when I saw. You have a great day, sir.
Thank you, Your Honor. You have a great day too.
Yes, sir.
Just for the record, he does have a 16 non-arrest bat DV, same victim. 2017 CF bat by strangulation, same victim.
That's what I was trying to figure out. Who is
2014 CF Agbat DV and Agbat pregnant person, same victim. 2012 misdemeanor bat DV with a different victim. So I have a 16,
when was the most recent case?
17 CF bat by strangulation. Then a 16 and a 14.
Based on those lethality factors that I have to look at in that case, the court's going to set your bond in the 2021 MM 3921AO in the amount of $5,000. Same conditions, no contact. For some reason, y'all can't figure out how to live at peace with each other. But
Your Honor, she doesn't reside with me.
I'm saying, I don't know where she resides or whatever. Like, I don't know if y'all just
My
oil and
parents'
water.
house, Your Honor.
I don't know if you guys just oil and water or whatever's going on, but something needs to change, obviously. Because I'm just telling you, apparently something needs to change.
I mean,
Well-
I'm not,
Don't talk about the facts, don't.
Your Honor, I'm not going to talk about any of the facts. I just wanted to state that that's the designated place to transfer the child. That's what it is. That's why
Yeah.
we're at my parents' residence.
Right.
That's all.
Yeah, so maybe maybe you don't need to be there when she's there.
Apparently.
Yep, there we go. Have a great day.
Thank you, Your Honor. Thank you, everyone in the room.
Oh, Lord. Can't tell me your name, sir.
Daniel Ramos.
Mr. Ramos, you're here in case 2021 MM 3931AO on charge of battery dating violence. Did review the charging affidavit in this case, did find probable cause. What's this? See, I think it's another one where they didn't, qualify them as a dating couple under the law, if I remember reading this correctly.
At the top, Your Honor, it says Desiree and Daniel have been dating for 3 years.
Yeah, but,
The nature of their relationship was characterized by expectation
I
of
see it.
affection or sexual involvement.
all right. All right, sir, in that case, the court is going to set your bond in this matter amount of $1,500. Condition of your bond that you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Can I ask a question?
I'm going to ask Ms. George a question because everything you asked me is on the record. morning, sir. Can you tell me your name?
Ray Smalls.
All right, Mr. Smalls, you're here in case 2021 MM 3934AO on charge of battery domestic violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. Going to set your bond in this case amount of $5,000. Condition of your bond is you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement. Must be turned over to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. Do you have any questions about a no contact order, Mr. Smalls?
No.
I can't hear you.
No, sir.
All right, I'm going to appoint the public defender to represent you in this matter, sir. You have a great day. All right. Alagazia, bonded, and then now Mr. Gonzalez. Can you tell me your name, sir?
Samuel David Gonzalez.
Mr. Gonzalez, you are here this morning in 2021 CT 3775AO on a failure to appear warrant. The judge signed your warrant, set your bond amount of $2,000. Is there an offer for Mr. Gonzalez to resolve his case today?
Yes, Your Honor, the offer was an adjudication, credit time served.
And Mr. Gonzalez, did you want to take that offer of adjudication guilt credit time, sir?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And you put your hand down. Sir, you're here in case 2021 CT 3775AO on a charge of driving while license suspended. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
You want to enter a plea of guilty or no contest to resolve this case today?
No contest.
Do you understand by airing a plea of no contest, you're going to waive all the rights outlined on the plea form that you're looking at right now?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Do you understand by airing this plea if you're not a United States citizen, it could subject you to deportation?
Sure.
I can't hear you. You understand if you're not a United States citizen, you can be deported from this country based on this plea?
Yes, sir.
You understand that this conviction at a later date, if you're charged with the same crime, can be used to enhance your sentencing up to a third-degree felony?
Yes, sir.
You all stipulate to a factual basis?
Yes, Your Honor.
Based on the stipulation, the court's going to find that there's a factual basis to enter this plea. Going to accept your plea of no contest, finds your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge. I'll give you credit for the 2 days that you have in Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $306. I'll make that payable directly to the clerk within 1 year of today's date. You have 30 days from today's date to appeal your judgment sentence in writing. You have a great day, sir. Thank you. Okay. All right, on to arraignments. All right, it's 2021 CT 3877AO. Mr. Barton is represented by the Public Defender's Office. You want to waive his arraignment?
Yes, I'll waive and enter plea of not guilty, Your Honor.
All right, he has another case, 2021 CT 3876AO as well.
Yes, I'll waive and enter plea of not guilty.
All right, we'll set both of those cases for Division 82.
Division 82, pre-trial conference is July 19th, 10:30 a.m., courtroom 10B.
All right, this is also 2021 CT 3909AO. Mr. Johnson is represented by the Public Defender's Office. You want to waive his arraignment?
Yes, I'll waive and enter plea of not guilty, Your Honor.
All right, set him for Division 82 as well.
July 19th, 10:30 a.m., courtroom 10B.
Good morning, sir. Can you tell me your name?
Good morning, Your Honor. Brandon Alexander Knox.
Mr. Knox, you're here this morning for arraignment in case 2021 CT 3968AO on charge of no valid driver's license. That's a second-degree misdemeanor. It's punishable to 60 days in the county jail and a $500 fine. You're represented by the public defender's office. Ms. George, you want to have a plea on behalf of your client?
Yes, Your Honor. We're going to enter a plea of no contest. The state is offering an adjudication of guilt, credit time served. Mr. Knox wants to accept the state's offer.
Ms. Knox, can you raise your right hand and be sworn in? Yeah. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
You put your hand down, sir. Sir, you're here in that case, 2021 CT 3968AO on charges of no valid driver's license, second-degree misdemeanor, 60 days in the county jail, and a $500 fine are the maximum penalties for that charge. Do you understand that?
Yes, Your Honor.
Ms. George is telling me that you want to enter a plea of no contest. Is that correct?
Yes, Your Honor.
Do you understand by entering a plea of no contest, you're going to waive all the rights listed on that plea form that's in front of you right there?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Have you now or in the past been diagnosed with a mental health illness?
No, Your Honor.
Has anybody forced, threatened, or coerced you to enter this plea?
No, Your Honor.
You understand by entering this plea if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
Do the parties stipulate to a factual basis for this plea?
Yes, Your Honor.
Yes, Your Honor.
Based on that stipulation, the court is going to accept that factual basis and accept your plea of no contest. Finds your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge. I'll give you credit for the 42 days, that you spent in Orange County Jail with 42 days credit time served. Apologize for that. The court costs and costs of prosecution in this case are $306. There's a $50 public defender lien and a $50 public defender application fee. All those costs will be payable directly to the clerk within 2 years of today's date. You have 30 days from today's date to appeal your judgment, sentence, in writing. You understand that?
Yes, Your Honor.
All right, have a great day, sir.
Thank you, sir.
All right, this case 2021 CT 3874AO. Mr. Zalabella Alua is represented by the public defender's office. You want to waive his arraignment?
Yes, I'll waive and enter a plea of not guilty.
All right, we'll sum for Division 63.
Division 63, pretrial conference, July 1st, 1 p.m., courtroom 12C.
Good morning, sir. Can you tell me your name?
Victor Calderon.
Sir, you're here in case 2010 MM3386AO on charges of battery and 2 counts. Both of those are first-degree misdemeanors. Both of those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes, sir.
And Ms. George, you going to have a plea on behalf of your client?
Yes, Your Honor, not guilty.
All right, sir, we're going to accept your plea of not guilty. We're going to set you for Division 50.
Pretrial conference day will be July 6th, 1:30 p.m., courtroom 7C.
Good morning, sir. Can you tell me your name?
Marcus Dallas.
Mr. Dallas, you're here in case 2021 MM2749AO on charges of resisting officer without violence and trespass on property after warning.
Your Honor, we only filed the resisting without.
Okay. Guess you're here only on charge of resisting officer without violence. That's a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand? 1 year in the county jail, $1,000 fine. Do you understand that?
Sir.
Represented by the Public Defender's Office, Ms. George, you have a plea you want to enter on behalf of your client.
Yes, Your Honor, the state's offering adjudication of guilt, credit time served, and we're going to enter a plea of no contest.
Okay. Mr. Dallas, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Put your hand down, sir. Sir, you're here to the case 2021 MM2749AO on charges of resisting officer without violence. It's a first-degree misdemeanor, punishable by 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
Ms. George tells me that you want to enter a plea of no contest. Is that correct?
Yes, sir.
You understand by entering a plea of no contest, you're going to waive all of the rights outlined on that plea form that's in front of you.
Yes, sir.
Are you under the influence of any drugs, alcohol, and medication?
Yes, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
Has anybody forced, threatened, or forced you to enter this plea?
Yes, sir.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
Did the party stipulate to a factual basis?
Yes, Your Honor.
Yes, Your Honor.
Based on that stipulation, the court will find a factual basis. I will accept your plea of no contest, find your plea is freely and voluntarily entered. I will adjudicate you guilty of the charge, give you credit for the 48 days that you spent in the Orange County Jail with 48 days credit time served. The court costs and cost of prosecution in that case of $273 is a $50 public defender application fee and a $50 public defender lien. I'm going to make those costs payable directly to the clerk within 2 years of today's date. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes, sir.
All right, have a great day, sir. Good morning, sir. Can you tell me your name?
Yes, sir. Travis John Dykers.
Mr. Dykers, you're here this morning in case 2021 MM3819AO on charges of criminal mischief in the second degree. That's a 60-day, it's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Correct.
Now, I have a note here that, is Mr. Dykers here on other cases? My note says he was RR'd the other day, which kind of doesn't make sense for him to do that since he's not getting any credit for standing in front of me right now.
Your Honor, per what I'm looking at, he had a 33-day motion that was denied in 21 CF 4780, which was a Burke structure and a criminal mischief.
All right. Well, is this case can be resolvable right now, or?
No, Your Honor.
All right, so you're represented by the Public Defender's Office. Ms. George may want to look into that, or your client's not getting any credit while he's hanging out here with us. But you want to enter a plea of not guilty on his behalf?
Yes, Your Honor, I'll enter a plea of not guilty.
All right.
May I say something, Your Honor?
Everything you tell me is on the record.
Yeah, that's fine. I want it to be on the record, please.
Okay.
Is this case going to be resolved today?
I can't be resolved today because I need a victim here.
There is no victim. There was a victimless crime, supposedly a crime. It wasn't even a crime. I went inside a swimming pool. I'm going to keep my cool the best I can. There's no reason for me to be in jail. I should have never been arrested. I just arrived in Orlando to try to make Orlando my new home. I was waiting for this place to open. She said 9 o'clock it would open. I could talk to the people about financing the unit then. I thought maybe it was a good place to rent. Little do I know, I was on OBT and it's not a good place to be. Okay, I went inside a swimming pool. I didn't damage no fence. I would have never damaged the fence. If I would have damaged the fence, I would have tried to resolve it then with the lady. But I was asked to leave because I wasn't a registered guest. She said I didn't have permission to go in the pool. So I walked across the street to the bank to get some money transferred to my account because I have family in Polk County who will take care of me. Okay? The bank wasn't open. The officer said because of the COVID-19, I had to call this number or go online to get a bank account. So I walked across the street to the Mercedes dealership where they had used cars. I was trying to finance a car so I could try to go on my way and make something happen while I was here in town. I had an interview, an appointment arranged for later on that day. I was supposed to be on the east side of Orlando to rent a room, and I was going to try to just make my life. There was no crime here. There's no evidence of any crime. There's no reason. If it holds 60 days, I should have been ROR'd in first appearance. I should have never been arrested in the first place. There's no reason why the state can't give me time served. I'm willing to do a no contest just to resolve it so I can get on with my life. I've got PTSD. I was diagnosed from my 5-year big, so my friend died. This is injustice. It needs to be resolved today. Period.
All right, well, can't resolve it today. I mean,
I don't have a restitution amount. I know.
Said $200. I didn't damage no fence, is what I'm saying, Your Honor. The fence was damaged where I went in. Every gate was chained locked. There was nobody at the pool. There was nobody outside. The maintenance man told me to leave. I wasn't supposed to be there because I wasn't a registered guest. So I did.
This Black Robe people think I got all kinds of powers. I really
got
don't.
arrested said $200 restitution, but I said, what do you mean? You said you were trespassing me. Now you're arresting me for a misdemeanor? I didn't commit no misdemeanor. I didn't commit no crime. He said, well, she says you damaged the fence. Take it to court. That's what the officer said.
Yeah, so we can. You got trials. We got, you know,
I've been there
if you wanna
44 days on a
request a
charge I'm not even guilty of. That's injustice.
request a bench trial.
State, can't you do something?
I can't convey an offer at this time. I don't have a restitution amount or a victim. I know the ASA reached out, I believe the last time she spoke to them regarding restitution was the end of May. Trying to
I
get
mean, it's obviously some kind of
Wait,
scheme.
a second. Wait, hold on. All right, so your options, like anybody, right now at this point, you can either A, I don't have enough information to resolve your case right now. I don't know anything about the case.
I just told you everything.
Yeah, but I don't have enough information. That's like, I don't have to read the file. I need to have somebody else here. That's their property. They said, they claimed there was damage. They have right to be heard. Constitution tells me that I have to do all that. Step 2, you can set your case for trial. You have a public defender representing you in Division 85, which I think is big.
Hey, Allen.
Judge Allen. You have a public defender representing Judge Allen. You got options there. He said for a jury trial.
Can I go
You get a
for a
bench trial?
non-jury trial this week then? Because
Yeah,
it's
call
injustice.
your public defender. Tell you want a bench trial.
I call all the time. I get a voicemail, I leave them voicemails, let them know what I want to do. She visited me. She says, what happened? Did you go to court for the 33-day motion? I said, no. She says, well, I'm looking into it. She says, they must not know what they're doing because you should have been ROR'd.
Well, the problem was, it looks like you ROR'd on one case and then you were denied ROR on another case. So that, I mean, which is true, you're not in custody on this particular charge. You seems to be on custody on a
Your Honor,
felony charge.
It came in as a Berg structure and a criminal mischief. We only filed a criminal mischief.
Yeah.
All
So
right,
it was denied for that ground.
That's what I'm trying to figure out. Why is he here if he's been ROR'd?
Exactly.
It was denied?
It was denied because we filed the criminal mischief.
Okay, I got what you're saying.
Yeah, you said there was no probable cause on the burglary because it was a swimming pool. You can't burglarize a structure, a swimming
Okay.
pool. It's a structure, and I didn't burglarize anything. I've never burglarized anything.
So you filed a criminal mischief, so when they filed information, so he's not ROR'd, he's actually getting time then.
There was nothing criminal I did, and it was not mischievous. It was pure-hearted. I took a 1-minute dip in a pool.
Yeah,
I was cooling
That's
off.
what it says in here.
The 20 CF case that he's in jail on.
He's not in
It's the
jail
same
now.
case.
Yeah, the same case, but,
Yeah.
yeah, okay, so he's collecting time, whatever. So I just want to make sure that he wasn't,
It carries
Just
60
sitting here.
days. I've been here 44 days.
so you should have a
State
bond, what's
expects-
this bond on the?
In 15 days, they can do what they haven't done in 45 days. I mean, let's just get realistic and reasonable here, please.
Does he have a bond on this charge? That's what I'm trying to figure out. Or what was the bond?
The bond on the criminal mischief looks like it was $250. I don't know if that's what pretrial has.
All right, so it seems like you got money in the bank account, you can bond yourself out.
No, it was my mother. She won't answer the phone. I came to Orlando to start a new life. I got arrested my first day, so she's like, she's done with me, my brother says.
Okay.
When I get out, she'll be there for me, but while I'm here, she doesn't want to talk on the phone.
Okay. All right, well, we hopefully can get you to a trial as quickly as possible. This next time you write a letter with Judge Allen requesting your trial.
One more question.
Let's set him for Division 85 pretrial conference.
June 28th at 9 a.m., courtroom 4A.
All right. All right, have a great day, sir.
That's 19 days from now. That's past the 60 days the case carries. I'm trying to figure out how that's even legal. That can't be legal. If the case carries up to 60 days, that would be 19 plus 44 would be like, what is that? 53, 63 days. That's more than 60 days. How's that even, that's not justice. That's illegal, right? I'm asking.
Well, you can't be sentenced longer than 60 days.
But then
Now,
how
the
can I
problem-
go in jail?
The catch-22,
Right?
yeah. Yeah. But the catch-22 about that is, technically, you'd be in custody for longer than 60 days.
It doesn't even make no sense.
I
have a bond, though. I
You
still
do have a bond. You can bond out. So
Somebody here bond me out, please.
I don't know if we can do that. All right. Have a great day, Mr. Dykers. All right. Hold on, give me 1 second here before we continue our fun for the morning. All right, 1 second. Hold on. All right, this is Mr. Haddon in 2021 MM 3385AO. He's represented by the Public Defender's Office on a charge of trespass on property other than structural conveyance. Refusal to leave. Do you want to enter a plea on his behalf? Ms. George.
Yes, I'll waive and enter a plea of not guilty.
All right, we set up for Division 80.
Division 80 pretrial conference is July 22nd at 9 a.m., courtroom 9C.
Mr. Lorgette.
Yes, Mr. Honor.
All right. Is that, say your name for me?
Loja.
Legent?
Yeah, Loja.
Okay. Mr. Legent, you are here this morning in case 2021 MM 3812AO on a charge of trespassing a structure. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Represented by the Public Defender's Office, was there an offer or a plea you want to enter on behalf of Mr. Legent?
No, Your Honor, there's no offer, so we're going to enter a plea of not guilty.
Okay. All right, Mr. Legent, we're going to enter. Is there a reason why you can't resolve
The
the
true victim
trespass?
case, Your Honor.
Huh?
The true victim case.
All right. Mr. Legent, I'm going to say your offer, your plea of not guilty. We're going to set you for Division 84.
Division 84 pretrial conference is July 12th, 9 a.m., courtroom 4B.
Good morning, sir. Can you tell me your name?
Lennox Reyna.
Mr. Reyna, you're here in case 2021 MM 3019AO on charges of battery domestic violence. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
Represented by the Public Defender's Office, Ms. George, do you have an offer or a plea you want to enter on behalf of your client?
Yes, Your Honor, we'll enter a plea of not guilty.
We'll set you for Division 50.
Division 50 pretrial conference is July 6th, 1:30 p.m., courtroom 7C.
All right, sir. Have a great day. All right, this is Mr. Smith in case 2021 MM 2680AO. He's represented by the Public Defender's Office on a charge of trespass on property other than structural conveyance.
I'll waive and enter a plea of not guilty, Your Honor.
All right, we'll set him for Division 85.
Division 85 pretrial conference, June 28th at 9 a.m., courtroom 4A.
All right, tell me your name, sir, please.
Beatrice Spires.
Mr. Spires, you're here in case 2021 MM 3006AO on charges of criminal mischief. That's a second-degree misdemeanor. It's punishable to 60 days in the county jail and a $500 fine. Represented by the Public Defender's Office, Ms. George, what do you want to do with the case?
I'm going to enter a plea of not guilty, Your Honor.
All right, Mr. Spires, I'm going to accept your plea of not guilty in this case. I'm going to set you for Division 83.
If I pled out today, could I get time served?
There's no offer. Convict.
There's no offer for today.
Pretrial conference is July 12th, 9 a.m., courtroom 6C.
So everybody, does anybody have anything else for this morning?
Nothing from the state, Your Honor.
Yeah, recess.
It is 1:31 PM, Wednesday, June 9th, 2021. If I could please have counsel for the parties put your appearance on record.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Are we calling this attorney first?
Who do you have first?
Carter's third,
Shelley, the virtual.
but I can do Carter first. Doesn't matter to me, it was third. Please tell me your name. I'm sorry, one more time?
Felicia Fordyce.
Ah, I see. Are you also known as Darnita Carter?
No, ma'am.
Did you say no? All right, this is 21 MM 3925. You're here charged with trespass, possession of drug paraphernalia, and resisting an officer without violence. There is probable cause. Is there an offer in this case?
Not at this time, Your Honor.
All right. I'm going to appoint the Public Defender's Office to represent you. I'll stay your bond at $500 on count 1, $100 on counts 2 and 3. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You're also not allowed to return to the Walmart on South Orange Blossom Trail. Do you understand that?
Yes, ma'am.
All right, good luck.
I'm getting out today?
You're not. Yeah, well, you can bond out.
Okay.
You can bond out today if you'd like. Do I just do this? Are they already connected? Okay, let's see.
Welcome to an Econo meeting. You are entering the meeting now.
Good afternoon, this is Judge Gibson. Do I have anyone on the line?
Yes. Hi, this is Lizette Dominguez.
I lost you, but I see Mr. Bigney.
Can you hear me okay?
Ah, yes, sir, I can hear you.
Okay, I wasn't first, so I'm more than happy to wait.
Who's your client, Mr. Bigney?
Who am I here for today?
Well, let me ask this
I'm
instead.
here
Do
for
you have?
Jared Shelley.
Oh, that's who I have. You are first right now, because that's who I have here at the podium. This is 19 CF 17133. And I'm sorry, Counselor, I don't think you put your appearance on record. I just called your name, so if you'd like to.
Yes, certainly. David Bigney on behalf of Jared Shelley.
All right,
Yes,
Mr.
I
Shelley, you're here because a warrant was issued for your arrest for violating your probation by leaving your county of residence without first procuring the consent of your probation officer. There is no bond authorized on that warrant. Mr. Bigney, did you wish to be heard on anything on this case?
Again, I just, not to beat a dead horse or to repeat you, I understand another judge has already found probable cause and issued a no bond warrant. Is that correct?
Yes, sir.
Okay, so with reference to the probable cause, no, I don't have any argument. Would the court be inclined to hear argument towards a bond?
The court will hear any argument you'd like to present, Counselor.
Thank you so much. No, Your Honor, I've been in constant communication with Mr. Shelley. This is in reference, the primary issue here is I believe you said an out-of-state arrest. Is that correct?
One moment, I didn't realize there was another page. Hold on, let me tell you the rest of the allegations, sir. That's correct. There was an out-of-state arrest for trafficking in cocaine and possession with intent to distribute marijuana and trafficking in a counterfeit substance. So I apologize. It's all of those things that allegedly violated your probation.
Thank you, Your Honor. With reference to that, again, I understand that these are out of state. I have not read the probable cause affidavit for those, but based on representations that have been made to me, all I can tell you is it's my understanding that that case is likely to end up going away. I know you don't have that information either, and I don't have that firsthand, but I'm hoping that the court will take that into consideration. That's not something that just happened yesterday. The charge has been around for a little bit. So there's a lot of unknown there. They did release him on bond on that case. We would ask that the court take into consideration that the fact that state is not requiring him to be incarcerated based on those charges. And we would ask that the court in this case also take that into consideration. Again, I want to emphasize to the court that I've been in regular communication with my client. And I have, obviously I'm not posting the bond, but I can tell you that there's been no issue with reference to that communication or his availability. So we would ask that the court consider a bond, even with bond restrictions.
Any response by the state?
Yes, Your Honor. I understand Mr. Bigney's argument regarding South Carolina giving him a bond. However, that is a new law offense, and he was entitled to a bond on those offenses. He's not entitled to a bond on a VOP. In addition to his VOP, he also does have an out on bond case for possession of a firearm by a convicted delinquent, which is an F2. And I have no knowledge as to whether South Carolina is pursuing those charges. They are from 2020 and they are still open. So it is my understanding, I don't know what's going on with them. Given that it is a VOP, state would ask that you hold him no bond until those other charges and the VOP court can see him and sort that out.
Let me ask you, Counselor, you just listed the possession of a firearm by a convicted delinquent, but I have also possession of cannabis with intent to sell with a weapon, possession of cannabis greater than 20 grams, possession of amphetamine, possession of a controlled substance, possession of a firearm and commission of a felony, possession of...
Your Honor, I can speak to that. It came in with 10 charges. We only filed the possession of a firearm by a convicted delinquent on that out on bond 6515 case.
Can you advise the court why? Or Mr. Bigney, can you? It says that you represent him in that.
Yes, I'm more than happy to, Your Honor. This is a joint constructive possession case without any confessions, without enough evidence to necessarily charge Mr. Shelley over anybody else that had access to that house. In fact, I'm pretty sure, and please don't take this as gospel. I don't have that file in front of me right now, but I'm pretty sure that Mr. Shelley was not in the house at that time. But don't hold me to that. I think that he came over to the house during the search. But again, I'm going on memory.
Your Honor,
I have two cases that are very similar.
In the out on bond case, I believe it was a search warrant on a house that was occupied by several occupants. DNA belonging to Mr. Shelley was found on 3 of the firearms, which is why he was charged with a possession of a firearm by a delinquent. And there was also a gun found on his bed or where he was believed to have slept. So he has a firearm case and arguably in a house with drugs. He was on a VOP for possession of a weapon when he shouldn't have been in possession of one. Then he was arrested again for not talking to his probation officer and picking up more drug charges.
So Mr. Bigney, thank you, Counselor. I'm sure that you understand the reason for my questions. What concerns this court is while out on bond for very similar charges, which appear to be drug trafficking while armed, your client is arrested out of state on charges of drug trafficking. So while I'll consider any argument for bond, I'd also like it if you could advise the court what reasonable conditions of bond this court can place on your client that will balance the safety of the citizens of Orange County, Florida. As your client's already been out on bond and violated that bond, so he's violating court orders. I need to know what reasonable conditions I can place on him. And if you
Certainly.
have a suggestion as to bond.
I do, Your Honor. First of all, with reference to the new violation, again, it is my recollection that he was not in the house. I understand that they believe that he was on the bed or something along that line. With reference to the actual, I believe they said that there was a print or some DNA on the firearm. I believe, again, not gospel, but I believe it was a mixed DNA. So then the question becomes, if his DNA is on there, did he put it on there, or was it a touch DNA by somebody else that lived in that house? But they did not have him in the house. And I know that it's one of these, it walks like a duck. It must be a duck type of cases, but I don't believe they actually have it. It's a constructive possession case. So there's not only a venue issue on that case, a jurisdictional on that issue on that case. There's also a time type of issue on that case, the statute of limitations on that. Who knows when that DNA got there? But that being said, I can tell you that he wasn't there at the time when that was found. The warrant was done, I think, without him being in the residence. So I understand the concerns that the court has on that, and all I can do is tell you what I believe, and I've certainly just hand-fed the state the defenses that'll be coming on that case, which is fine. But there's a reason why there's only one charge filed on that. So as far as those charges, yeah, they're out there, Your Honor. But PC is a very low standard, and that's what got him arrested. As far as conditions of bond, certainly I'm not going to sit here and suggest that the fact that he was arrested for that similar charge shouldn't be of concern to the court. We certainly acquiesce to that. But as far as conditions that might be something to satisfy the court's concerns, might be some sort of ankle monitor. We can make arrangements for that. I'm not sure that necessarily a curfew is something that would be a good idea necessarily for an adult. I'm not sure what my clients need to be out from, say, midnight to 6 is, but those are the types of things that might be out there. I know that I can say, hey, no firearm, but I think that the court has already addressed that concern because he subsequently picked up that charge. But certainly throwing that out there as well. Those are some of the things that I would think of. Also, pretrial release, if he needs to check in once a week, then that might also satisfy the court's concerns. From a financial standpoint, I can tell you based on my conversations, not only with my client, but with family, the financial resources are not substantial. I would ask that if there was a bond granted, that it be somewhere in the neighborhood of $5,000 to $10,000. I believe the family can come up with that to help my client with any of those other conditions or anything else that the court might need to impose to satisfy the conscience of the court.
Any response by the state?
Yes, Your Honor. Several things. In regards to PTR, he does not qualify given his history and that he's out on bond. Given ankle monitoring, that's also not something available to this court. So both the suggestions that Mr. Bigney made are both not available to this court at that time. And Mr. Shelley has shown an inability to comply with both court's orders as well as comply with probation. So even if setting a bond and putting him back on probation, it would seem like a futile attempt, as he's already shown an inability to comply with court orders as well as probation and his probation officer.
May I briefly respond, Your Honor?
Yes, sir.
Yeah, and I'll be quick. First of all, with reference to the PTR, I'm not suggesting that he be released on PTR. I'm suggesting that he maybe be required to report as part of his monetary bond. So it's not, hey, let's release him just on PTR and he'll be good to go. So it's just another another thing that the court can use to just keep tracks on him. As far as the ankle monitoring, I have an ankle monitoring company that will, if the court was willing, that will put a monitor on him and will monitor him and will be required to report to the court any violations of any conditions with reference to that. So while it's not a program that the court generally uses, Court Programs is a company that this county has used over the course of probably the last 10 plus years. And I know that they will, if that's an opportunity, if that's an option, that they will monitor him. And quite frankly, if they don't monitor him, then he's going to be stuck on the inside regardless. So that is an option that is available. It's just not something that's necessarily handed to the court as a tool, but it's something we're offering to the court. We've done that work already for the court, for the state to say, hey, we've got this available. And the court and the state have used this program for many, many years.
And who pays for that?
What's that?
Who pays for the monitoring? So in
Who
this
would be
case, if I order
responsible?
it,
My client would be responsible, Mr. Shelley would be responsible for the cost himself.
Your Honor, for the record, state's objecting. I have no idea this private company, and if that determination is made, I believe that determination would be better made by the VOP court, whether they want to potentially exercise that option. But at this time, state's objecting to a private company that I know nothing about monitoring Mr. Shelley.
all right, thank you, I appreciate that. Mr. Bigney, I hate to inconvenience you, but I've taken all of your arguments into account. I'd like to take one more step, and that is I'd like to contact Judge Roche, who's the judge who issued this warrant. While I understand that it's within this court's discretion to issue a bond on a violation of probation because your client's not entitled to it, this court typically doesn't do that without speaking with the trial court. So what I'd like to do is see if I can get in touch with her. So can we recall this case it'll be this afternoon, just at some point in the hearing time. Is it possible to recall you?
It certainly is. Can I get some sort of heads up, or do you need me to stay on the line the whole time?
No, I don't know how long it will take me to get in touch with her. I should be in court at least an hour and a half, perhaps longer. We just started and we have a fairly large docket today. I think I have your cell phone number so we can text you.
Great.
And then if you can just hop back on, will that work?
That'll work just fine. In the interim, what I'll do, and I know it might not matter, but just to do my due diligence, I will reach out to Court Programs to see if I can get you some of that information in the event that Judge Roach is okay with the bond being set in this case. I can hopefully be able to provide you with that information in advance between now and then. And if I get anything for you that I can email, I'll email your JA between now and then.
That's wonderful. Thank you so much. We'll recall this case.
Thank you very much.
Thank you, sir. Counselor, who's your client?
Yes, I have Clifford White.
We have him. Hold on one second. And I'm sorry about earlier, Counselor. I heard you introduce yourself, but it cut out and then you disappeared. And then I saw Mr. Bigney, so I
It's okay. It's Lizette Dominguez for the record.
wasn't intending to skip over you.
Your Honor, Clifford White, he bonded.
Oh, Counselor, your client bonded out.
Okay, I had a slight feeling that had happened. Okay, I believe it may have been addressed in the morning session. I don't know.
No, he bonded, so
It wasn't a judge.
I don't think he saw a judge today.
Okay, thank you, Judge.
Absolutely. Again, I'm sorry for making you wait.
No, that's okay. Thank you.
All right, have a nice day. Well, I'm sorry about that. Okay, I'm gonna end this call. Anyone else on the line? No. All right, we'll go back to that in a minute. Sir, please tell me your name.
Robert Crew.
21 MM 3928. You're here charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, the offer conveyed was an adjudication, credit time served, and no return.
Ms. George, did you have a chance to review that with Mr. Carew?
No, I didn't, Your Honor. I called out to him in the cell, but I'm assuming he was on a side cell because he's in chains.
All right, let me ask him. Mr. Crew, please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Did you hear what the state attorney just said? You can put your hand down. Is there offer for you?
In adjudication of guilt, credit time served, Your Honor.
Are you interested in accepting that offer today?
Yeah. How long would that have?
Speak into the mic so I can hear you.
How long would I be in jail or?
It means that you'd be released at some point today.
Okay. That works.
I'll sentence you today.
Yeah.
But before we do that, I need to make sure you understand the rights you're giving up. Ms. George, do you have a minute to explain that to him? Let me see if I can.
Your Honor, Mr. Crew does understand all the rights he would be giving up and would like to accept the state's offer of an adjudication of guilt.
All right, Mr. Crew. Do you have any questions for me about the rights you're giving up? You understand that you have a right to a trial by jury where one is required, but we're not going to have a jury trial if you enter a plea of guilty or no contest today.
Yeah.
All right, you understand that if you're not a U.S. citizen, this plea could deport you?
Yeah.
You understand if you're on probation, this plea could violate that?
Yeah.
Has anyone threatened you or promised you anything to get you to enter this plea other than the state's offer?
No.
All right, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs. Sir, do you have a job?
Not at the moment, no.
All right, if I give you a year to pay your court costs, do you think you can get that paid? All right, I'll give him a year to pay that. Do you have any questions for me?
No.
All right, good luck, sir. You have 30 days to appeal in writing. Thank you, Ms. George.
You're welcome.
We got one Spanish and one sign. Okay. Good afternoon. Please tell me your name. All right, you're here in 21 MM 3932, charged with battery. I need you to put your mask back on. Thank you. Sorry, I know it's difficult, but we all have to wear them right now. There is probable cause here for your arrest, and I'm going to appoint the public defender's office to represent you. Your bond is $500.
Your
You
Honor,
can't, yes?
There was a weapon in this case, arguably a deadly weapon. There were scissors.
Yes.
That arguably Ms. Felder stabbed her in the left leg and chin area.
Yes.
State would ask for a higher bond, given that this should be charged as an ag bat with a deadly weapon. And given she has a pretty lengthy history.
Okay, ma'am, hold on, before we go any further, I just want to tell Ms. Felder something, just so that you understand, everything you say here is being recorded and can be used against you later. So you can say anything you want or ask any questions that you want, but I've appointed Ms. George to represent you, and you might want to talk to her first before you say anything. I just want to make sure you understand that.
Yesterday, she hit me in my mouth. When I came back, She had a weapon already. She didn't follow me, left me with dead. I was drunk, raped, and I lost my mom a week ago.
Your Honor, I would just ask that you stay. The bond, I don't think it's necessary to increase. I read the arrest affidavit. There were superficial scratches. And if you look, there is a history of mental health. So I would just ask that you take all of that into consideration and stay the bond at the original 500, Your Honor.
I also see that your client has 3 prior failures to appear.
Yes, Your Honor.
She appears to have a pretty significant criminal history.
Yes, I would just point to the fact that the last conviction was is showing 2018, and the last failure to appear was in 2013.
All right, Ms. May, I reviewed this probable cause affidavit, and it appears that there are many charges that the state could charge within this affidavit. However, she is at this time only charged with battery. So given the facts, the prior history, and the 3 prior failures to appear, I will set your bond at $1,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? Yes, ma'am.
I'm homeless with SSI, so if I made bond today, how? When they just gonna follow me and try to hurt me again?
Your Honor, again, I would just point to the fact that she stated she's on SSI. I'm asking you to stay the $500 bond. There is mental health issues, clearly, and I would just ask that you stay the bond at $500.
Hold on, let me ask a question. Can she be screened for mental health pretrial release?
She could be screened.
All right. I'm going to order that she be screened for mental health pretrial release. What that means, ma'am, is you won't have to post a monetary bond if you qualify for that.
Yes, after that, y'all can take me right to Lakeside or something? Like out of here.
Hold on, I don't have the jurisdiction to do that.
You just get out? I ain't never been qualified for that.
Ma'am, I don't have jurisdiction to order you into a mental health facility, but what I can do is order that you be screened for a program called mental health pretrial release. If you qualify, you would be released without having to post a monetary bond, but you have to follow the requirements of the program. You understand? You have to answer out loud.
Yes, ma'am.
And you're still not allowed to have any contact with the victim. You understand what that means?
I'm gonna stay far away.
All right, that's a good idea.
Like I'm, yeah.
You also cannot return to the Quick Stop located at 2507 North Hiawassee Road. Do you know where that is? All right, you can't go back there. You understand that?
Yes.
You can't possess a weapon of any kind, a firearm or ammunition. Do you understand that too?
Yes.
I'll also order that she must comply with any prescriptions as prescribed by a doctor or anything that a doctor orders.
Yes, Your Honor. Thank you.
Your Honor, if she doesn't qualify, is it the 1,000 for the mental health PTR or 500?
I'm going to make it $500 in the alternative with the same conditions. Good luck, ma'am.
St. Bill is mental health.
21MM 3929, trespass on property after warning. I'll appoint the public defender's office.
Your Honor, I'll waive the appearance. However, I would just argue that given the fact that he has little to no criminal history, I think the last trespass was in 2018, I would just ask for an ROR in this case. He's been in the Orlando area for over a year. He has 0 failures to appear. It's a nonviolent offense.
What says the state?
State will leave it within your discretion, Your Honor.
I'm going to grant that. So I'll release him on his own recognizance, but he's not allowed to return.
Thank you, Your Honor.
Please tell me your name.
Warren Cogswell.
This is 21 CF 6796. You're here charged with possession of methamphetamine and possession of drug paraphernalia. There is probable cause in this case, and I'll appoint the public defender's office to represent you. Your bond is $1,000 on count 1, $500 on count 2. You're not allowed to possess or consume a controlled substance without a valid prescription. You're not allowed to have contact with any known drug dealers. You're not allowed to have contact with any victim, witness, or co-defendant in this case. Do you understand? I'm sorry, what did you say? Do you understand?
Yes.
All right, did you have a question?
Yeah, I wanted to see about an ROR.
I'm not going to grant that request at this time, but call that number. Your attorney can file a motion to reduce your bond in front of the trial judge.
What does that mean? Someone else's fight, really? Yeah.
Please tell me your name.
Kathy Cox.
A capias was issued for your arrest in 20 MM 32 for failing to appear for arraignment on a charge of petty theft. The bond authorized on that capias is $2,000, and I'll appoint the public defender's office to represent you. In 21 CF 6758, you're here charged with grand theft of a motor vehicle. I'll appoint the public defender's office to represent you. There is probable cause in this case as well. I'll stay your bond at $1,000. With special conditions, you're not allowed to have contact with the victim or the co-defendants in this case. Do you understand?
Yes, ma'am, but I live with them. That's why I'm not understanding why a warrant was issued, because my sister gave me the keys to her vehicle and.
Don't talk about the facts.
So everything you say is being recorded and can be used against you. The only thing we're doing here today is I reviewed the probable cause affidavit, and there is probable cause for your arrest, but we're not having an evidentiary hearing today. It sounds like you think you have some defenses that you can raise. You'll want to talk to your attorney about that.
Can there be a one-time return, so she can gather her belongings from the household? Because they all live together, the victims.
Yes, I'll allow you to return one time with law enforcement to gather belongings, but you can't have contact with the victim or the co-defendant. You understand?
Yes, ma'am.
Any other conditions the state would request?
No weapons, Your Honor.
You're not allowed to possess a weapon, firearm, or ammunition. All right, good luck. Please tell me your name.
Richard Davis.
A warrant was issued for your arrest in 21 CF 6770 for attempted sexual battery on a child under 12 and lewd or lascivious exhibition by a person over 17. Another judge has already found probable cause for your arrest. What says the state as to bond?
Your Honor, he's entitled to bond. Count 1 is an F1, count 2 is an F2, so he's entitled to bond on both counts. State would just ask for a reasonably high bond, given that he is out on bond, which I believe was revoked on the 20 CF 10400 case, which was a sex bat on a person between the ages of 12 and 18.
So he has no bond on that case?
That is my understanding. I wanted to verify with the court that he was revoked on those other cases.
I don't have any information about that.
No, they have bonds. There is, one is 10,000, the other is 10,000, and the child abuse is 1,000.
Okay, so he has bond in that case. I don't have that case in front of me.
Your Honor, if he's out on bond on that case, can the court revoke those bonds today? He was out on bond on that case when he picked up this new case.
When was he released on bond on that case?
Can I say something? 'Cause I just got that. Yes.
I do see that they were revoked.
Yeah, he just
But
got-
he got a trial management conference today with Judge Laurent, who gave him his bond
Okay, so Judge Laurent reinstated the bond.
today.
Okay. So no, I'll not readdress those bonds that Judge Laurent already addressed.
Your Honor, the state would ask for high bonds on count 1 and count 2 with the intention of filing a pretrial detention motion.
And,
How long will it take you to file that motion, Counselor?
I would not be filing it. It'd be the other ASA that's in charge of this case, who I was in contact with before this case. So I'm not sure, Your Honor.
And-
But given that he's out on bond for child sex offenses and picks up additional child sex offenses, I don't believe a high bond is unreasonable.
When was that case, when were those incidents alleged to have occurred? And when was he arrested? Was an information filed?
On the 20 CF 10400, an information has been filed. That's the charges that you see in the sex bat on a person between 12 and 18, 2 counts of that, and child abuse. The alleged date of incident,
Well, it's a 2020 case.
yes, Your Honor, but the allegations in the case before us are from March 30th of 2021, so arguably it is before, just by nature of the case number. The alleged date in that case was June of 2020.
And when was he arrested?
September 27 of 2020.
And when did he bond out? Thank you.
September 29, 2020.
So he was out on bond for sex offenses when he is alleged to have committed these sex offenses as detailed in the warrant.
Yes.
Your Honor, I would just point to the fact that he was just seen by the trial judge. He did reissue those bonds. So I'd just ask that you take into account his criminal history. He has none, and take that into account when setting the bond amount.
Your bond on count 1 will be $50,000. Your bond on count 2 will be $10,000. You're not allowed to have contact with this victim or her family members. Do you understand what no contact means?
That's my cousin, the victim.
Right. You can't have any contact with her or any of her family members. Do you understand what no contact means?
Yes, ma'am.
You can't return to their residence for any reason.
Yes, ma'am.
You can't go back to your grandmother's house where this is alleged to have occurred.
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. You can't have any unsupervised contact. No, you can't have any contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
Hold on 1 second. I'll order that you must comply with any physician's orders. So if you have a doctor who prescribes anything, you have to comply. Do you understand that?
Yes, ma'am. When I got released, I was told to go to a lakeside and get mental health help. So that's what I'll be doing upon release.
All right, so then if a doctor orders you to do anything, you have to comply with it. You understand
Yes, ma'am.
that?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
I'll just tell my family.
Colleen rule is a refusal, Your Honor.
All right. 18 CF 13408, it's a violation of probation with no bond. I'll find her refusal a willing waiver of her appearance today. I'll appoint the public defender's office to represent her. In 21 CF 576, I find her refusal a willing waiver of her appearance in court today. This is a petty theft with 2 prior convictions. I will appoint the public defender's office. A warrant was issued, so another judge has already found probable cause. I'll stay her bond at $7,500. Spanish? Thank you.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good afternoon, thank you. If you could connect to the headset, please, and confirm he can hear you.
There is contact, Your Honor.
Sir, please tell me your name.
Carmelo Marrero Figueroa. Marrero Figueroa.
Carmelo Marrero Figueroa.
A warrant was issued for your arrest in 21 CF 6802, charging you with fleeing or attempting to elude law enforcement with lights and sirens activated. Another judge has already found probable cause for your arrest.
Qualifying for pretrial release. I would ask for pretrial release. He has no crimes. So I would just ask that he's placed on pretrial release.
What says the state?
Your Honor, I understand that he otherwise qualifies, but given the inherently dangerous nature of this offense, state would object. If you're otherwise inclined to put him on PTR, that's for bond and injunction in PTR.
What amount of bond?
I believe you usually set the fleeing and eludings at 15, so state would ask for half.
Ms. May, do you have the warrant or the affidavit for the warrant?
I can double check my system.
I'm missing the rest of the warrant and I don't have the affidavit, and I made a note about it and then forgot to ask the JA to track it down, so I don't have that information. Does pretrial have it? No? Okay, thank you.
I'm trying to figure out the correct combination of last names. And then come up.
It says with lights and sirens activated, but it doesn't say at high rate of speed, willful and wanton disregard. So I need to see the facts in the affidavit in order to determine bond versus PTR.
Your Honor, do you mind repeating the case number one more time?
21 CF 6802. I'm also texting the JA to see if she can get it. Yes, if she can't pull it up right now, we'll come back.
Your Honor, all I can see is the citation.
All right, I have that. All right, I'm sorry for the interpreter. We're gonna have to call you back.
Okay, Your Honor, do you want me to go right now or?
Yes, because this could take several minutes. So we'll recall you when we have the affidavit.
Our next case is also a Spanish interpreter.
Oh, we have another Spanish case?
I thought so.
I don't have it.
Vasquez is not? Oh, never mind. Okay.
Okay. All right, we'll call you back, Madam Interpreter.
Okay, thank you, Your Honor.
Thank you. Y'all, 3 cases in 45 minutes. This does not bode well.
And Your Honor, is this Vasquez we're waiting on?
No,
Oh.
the sign interpreter won't be till later. Sir, please tell me your name.
Robert Hurley.
You have to leave your mask on.
Robert Hurley.
21 MM 3930. You're here charged with open carry of a weapon or firearm. There is probable cause. Was there an offer in this case?
Not at this time, Your Honor. I'm
All right.
intending to upfile it.
I'm going to appoint the public defender's office to represent you. Your bond is $500. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
I don't have any. Oh, yes.
You understand that you can't have a gun and you can't have any ammunition?
Yes.
Is there a co-defendant in this case?
No, Your Honor.
All right. Any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Take it.
Please tell me your name. 21MM3936. You're here charged with prostitution. There is probable cause. Was there an offer?
No, Your Honor.
Your Honor, I would ask, in this case, given that she has no criminal history, she's been in the Orlando area for over a year, she's employed, I would just ask for an ROR in this case.
What says the state?
Your Honor, I'll leave it within your discretion.
Counselor, did you say your client's employed?
It says employed part-time, I'm just reading off of the face sheet.
Oh, where do you work, ma'am? I can't hear you.
Amazon?
Amazon.
I actually just started working there.
The face sheet says entertainment for a year.
Yeah. In what field is your degree?
My degree, I'm just working in the warehouse with Amazon. I was self-employed as of last year.
It says you're a graduate of college. What degree did you
I'm
get?
nursing. I was in nursing when I lived in New York. I had my LPN.
And how long have you been in Florida?
4 years. I was working in a pharmacy when I came out here for 2 years. And then COVID had happened. I got laid off and started doing online entertainment. And then from there, I branched out recently and made a mistake. I apologize.
Your Honor, she's never been arrested for this before, so I just ask that you take that into consideration.
I'm really not inclined to release on our own recognizance. I'm trying to get there, counselor.
Your Honor, the state now has a prostitution pretrial diversion, which Ms. Powell will likely qualify for, given that she does have no criminal history. So she'll likely get the classes and the knowledge as to the threats associated with this kind of charge. Since you would otherwise qualify for PTD, I don't know if that eases your mind at all.
All right, I'll release you on your own recognizance. Good luck, ma'am. Who? Okay. Please tell me your name.
Ines Joaquin.
21MM3935. You're here charged with resisting an officer without violence and trespass on property after warning. There is probable cause. Is there an offer in this case?
Yes, Your Honor, an adjudication, credit time served.
And Your Honor, we would ask for pretrial release to resolve this case later. She does qualify. I don't see any criminal convictions.
Hold on. Okay, so I had the sheet that says she doesn't.
It was updated.
I just got it. Thank you. Yes. Does the state object?
No, Your Honor.
All right, I'm going to place you on pretrial release with special conditions. You're not allowed to return to the racetrack at 350 West Sand Lake Road. Do you understand that?
Excuse me, can you repeat?
Hold on, I can't hear you. Get close to the microphone.
Could you repeat?
Would you please repeat it?
Yes, I'm going to place you on pretrial release with the condition that you're not allowed to return to the racetrack at 350 West Sand Lake Road.
Yes, miss.
You know where that is?
Yes.
And you can't go back there.
Okay.
You understand?
Yes.
You're not allowed to have any contact with the witness or victim in this case. Do you understand what no contact means?
Actually, excuse me? No, yes, I know, yes, miss, I know what contact.
All right. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
Lopez legal bonding, Your Honor.
Oh, this one bonded. Which one is that? But he just said this one bonded.
Lopez legal is the one.
Bonded. Yes. All right. What about Steve Lang? Oh, sorry, I thought we skipped you. So you're Steve Lang?
Yes, ma'am.
21 MO 437. You're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of illegal purchase or sale of alcohol. The bond authorized is $2,000.
Your Honor, this case, I don't know why it says that on the face sheet. This case is actually possession of an open container.
Well, the capia says illegal purchase, sale, or offer of alcohol.
Yes, Your Honor, I pulled all of the papers in it. It is a possession of open container.
Yes, Your Honor. My client stated it was, well, Mr. Lang stated it was an open container. And he would like to accept the state's offer here today of a withhold of adjudication credit time served.
Why would I withhold on this?
Is it
It's a city ordinance, Your Honor. That's all I've been authorized to offer on those cases.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, did you hear what Ms. George just said? As a friend of the court, I'm not appointing if they're not.
Yes, Your Honor.
You can put your hand down now. Do you understand all the rights you're giving up if you enter a plea of guilty or no contest today?
Yes, Your Honor.
You understand we're not going to have a trial. You're not going to testify or call witnesses to testify. You're not going to force the state to prove your guilt. You're going to enter a plea and I'm going to sentence you today. Is that what you want to do?
Yes, Your Honor.
Do you have any questions for me about those rights?
No, Your Honor.
Do you understand that if you're on probation, this plea could violate that?
Yes, I'm not on probation.
I believe you, but I have to ask everyone.
Yes, Your Honor.
You understand if you're not a U.S. citizen, this plea could deport you?
Yes, Your Honor.
Has anyone threatened you or promised you anything to get you to enter this plea other than the state's offer?
No, ma'am.
At this time, how do you wish to plead to open container of an alcoholic beverage?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for 2 days that you've been in jail. I have to order that you pay court costs, and I'll give you a year to pay them. Do you understand?
Yes, Your Honor.
Do you have any questions for me?
No, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
Thank you.
Robert Barr bonded.
Yes, Your Honor. Yes, Perez bonded. And then Stephanie Gonzalez also bonded.
Please tell me your name. I'm sorry, one more time? 21 CF 6757, you're here charged with possession of material depicting a sexual performance by a child greater than 10 images, possessing material depicting sexual performance by a child greater than 10 years. Okay. And another count of possession of material depicting a sexual two more counts, actually. So you have 4 counts of that charge. I reviewed the probable cause affidavit. There is probable cause in this case. I'll appoint the public defender's office to represent you.
All right.
I show that he's on state probation. Is there a hold for that?
I believe he's already been seen on that VOP and held.
Okay. Your bond will be $5,000 on count 1, $5,000 on count 2, $5,000 on count 3, and $5,000 on count 4. You're not allowed to have any contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
The state would ask that he has no access to the internet.
How do I enforce that?
It's been ordered before, Your Honor, I'm not sure. I mean, given that he's on probation, I guess probation may.
It looks like
That he not be allowed to access the internet?
I believe he's in DOC, is that, no? Your Honor, I would object. I would just ask that you order, he's not allowed to have any material, I guess, the sexual material.
It's a reasonable request. I'm just concerned about enforcement of that condition.
Because you can, I understand, Your Honor, I think the issue is that you use the internet for other things.
Right.
Besides what he's here for today. So I would just ask that when using the internet, it's not in a manner that violates the law.
I'm going to grant the state's request and order that you not access the internet for any reason. Do you understand?
Yes, ma'am.
Good luck, sir. We have the sign language interpreter in the courtroom. Hold on. Oh, I think they'll have to bring in.
No worries.
Okay, thank you, ma'am. Please tell me your name.
Area Austin.
21 CF 6744. You're here charged with grand theft of a motor vehicle.
Yes.
There is probable cause. I'll appoint the public defender's office to represent you. Thank you. I'll state your bond at $1,000. You're not allowed to have any contact with the victim.
Ashley Casimir, right? Oh, sorry. I'm sorry.
That's fine. No, you're
Right, no contact with Ashley Casimir.
No problem.
Your Honor, as to the out on bond, I would just ask that you not revoke the out on bond. And I would just point to the fact that this is an issue between two girlfriends. And it appears, if you read from the arrest affidavit, she did not believe she was allegedly stealing from the girlfriend, and reported the car stolen out of spite. Given the facts of the case and her limited criminal history, I believe she only has the out on bond case. I'd ask that you take that into consideration and not revoke her out on bond case.
Who's the victim of the battery case?
Victim of the battery is the witness in this case, who was in the vehicle.
That's my fiance.
And that case is.
So wait, the victim of the battery was the front seat passenger?
Yes. That's my.
Was there a no
fiancé.
contact order?
I'm looking into that now, Your Honor.
No,
happened-
it's no hostile contact. It's no hostile. It's not no contact. It's no hostile.
All right, thank you, ma'am.
No problem.
It occurred back in May 9th.
Yes.
Your Honor, Ms. Alston is correct. It's a no hostile or violent contact order.
What says the state as to the out on bond case?
Your Honor, I understand Ms. Alston's story that she doesn't, that is her account. However, we don't have the victim's account. So I just ask that you revoke and you double it.
Do you have the information in that battery case? Was there an information filed?
Not yet, Your Honor. It's only been a month since the arrest. And she has arraignment on it in about 14 days.
All right, I'm going to take no action in that case. Good luck, ma'am.
Thank you so much.
Right. Good afternoon, ma'am. Can you please tell me your name? I don't know if the record is going to pick you up, Madam Interpreter, because you're not near a microphone. Let's see if they can. Sorry, I want to make sure she can see you, but I also want to make sure that the record is clear that you're here. And I need to have the interpreter, if you can please tell me your name.
And I have not been sworn, Judge.
Thank you.
It's Julie Balassa, nationally certified interpreter.
Raise your right hand to be sworn.
Do you swear to translate from American Sign to English, English to American Sign to the best of your ability?
I do.
Thank you very much, ma'am. And thank you for your flexibility.
Of course.
All right, Ms. Vasquez, you're here in case 21MO676, charged with an open container of an alcoholic beverage. There is probable cause in this case. Let me ask if the state has an offer.
Yes, Your Honor. I've been authorized on the city's behalf to offer a withhold of adjudication and credit time served.
I'm sorry, what was the second thing?
Credit time served.
Ms. George, I assume you did not have the ability to talk with her before court, is that correct?
Yes, Your Honor, that's correct. I do have to inform and
All right. Ms. Vasquez, can you read the form that's in front of you?
Yes, I know, but I can't see because I don't have my glasses. So I need the interpreter to sign it for me, please.
I understand. We'll just walk down one by one. Ms. Vasquez, you understand that if you, well, did I swear her in?
I don't believe so.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do, yes.
All right, thank you. Are you interested in accepting the state's offer today?
Yes.
You understand that if you accept the state's offer and this court sentences you today, you'll be giving up certain constitutional rights, like your right to remain silent, your right to testify on your own behalf, your right to call witnesses and present any defenses you may have at a jury trial when one is required. You're giving up your right to force the state to prove your guilt beyond all reasonable doubt. Further, if you're on probation, this plea could violate that probation.
All right, I understand.
If you're not a U.S. citizen, this plea could deport you.
was born here in the USA.
Okay, I believe you, I just have to make sure you understand that.
No, I'm a citizen.
All right, do you have any questions for me about those rights?
No, I'm good. I understand everything clearly. I have respect for what you said.
Thank you, ma'am. At this time, how do you wish to plead the charge of possession of an open container of alcohol?
No contest.
No contest.
Ma'am, has anyone threatened you or promised you anything other than the state's offer to get you to enter this plea today?
Oh, no.
All right, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication. Give you credit for the 2 days that you've been in jail. I have to order you to pay court costs. Do you think you can pay that in a year if I give you a year to pay it?
Yes.
All right, I'll give you a year to pay it. Good luck, ma'am. You have 30 days to appeal in writing.
All right, okay. I understand, Your Honor. I can't see.
It's okay if she doesn't sign it, because she can't read it, but I think we qualified it. Thank you.
Interpreter.
Thank you, Madam Interpreter. It's so nice to see you in person. Wow, that's wonderful. Well, I don't know if you think it's wonderful, but I'm happy you're here.
Well, thank you.
I think it makes it easier for those defendants, so thank you very much. Have a nice day.
You too.
Sir, please tell me your name.
Joseph Blair.
20 CF 8269. A capias was issued for your arrest for failing to appear on a trial management conference for a charge of driving under the influence with 3 prior convictions. There's no bond authorized on that capias, and I'll appoint the public defender's office to represent you. Good luck, sir.
All right, sir. Yeah.
Sir, please tell me your name.
Jason Bronco.
21 CF 6781. You're here charged with burglary of a structure and criminal mischief, damage greater than $1,000. There is probable cause in this case, and I'll appoint the public defender's office to represent you. Your bond is $3,500 on count 1, $1,000 on count 2. You're not allowed to have any contact with the victim, any witness, or co-defendant in the case. Do you understand?
Yes, ma'am.
You're also not allowed to return to this scene. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand, sir?
Yes, ma'am.
Good luck. Please tell me your name.
Damian Cheney.
Sir, you're here because a warrant was issued for your arrest in 21 CF 5947, charging you with sale or delivery of cocaine. Another judge has already found probable cause in this case. I would set the bond higher. He set it at $5,000. I'll leave it there. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand that?
Ma'am.
You also can't have contact with any known drug dealers or possess a weapon, firearm, or ammunition. Do you understand?
Ma'am.
Good luck, sir.
I have
Yes.
a question. I was supposed to have court yesterday, but they had me in medical. So I was just wondering.
Here?
Yes.
Court for this charge?
No, for another one.
Okay.
So I was just wondering what the, I guess the outcome of that would have been, because I wasn't here, so.
I don't have that case in front of me. What you should do is call the public defender's office, call that number, and ask to speak to your attorney, and they can tell you what happened. I don't know what court that was.
It said the bond, it was here.
Oh, it was IA's.
Yeah, 10,000.
Oh,
It was the other sale and delivery of heroin, Your Honor.
I see. Okay, so it was here in front of me yesterday. I gave you a bond of $10,000 with the same conditions. Good luck, sir. Please tell me your name.
Egypt Croker.
Sir, you're here in 21 CF 6754. A warrant was issued for your arrest for possession of MDMA. Another judge has already found probable cause. Your bond is $1,500. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
I understand.
And you can't have contact with any known drug dealers. Good luck, sir.
Roderick Dallas, bonded, Your Honor.
Thank you. Please tell me your name.
Carlos Etienne.
21 CF 6785, you're here charged with carrying a concealed firearm and possession of cannabis less than 20 grams. There is probable cause. I'll appoint the public defender's office to represent you. I'll stay your bond at $1,000 on count one, $100 on count two. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, Your Honor.
You're also not allowed to possess a weapon, firearm, or ammunition, or have contact with any co-defendant in the case. In 20 CF 5627, you're here charged with 3 counts of violation of a condition of pretrial release. A warrant was issued for your arrest. There is no bond authorized on that warrant, and I'll appoint the public defender's office to represent you. Good luck, sir. And then Dexter, if we can bring back Mr. Bigney's client soon.
Yes, Your Honor.
All right, give me 1 second. Yes, thank you.
Tisha.
Please tell me your name.
Devontae Harris.
A capias was issued for your arrest in 18 CF 15907 for failing to appear for a status hearing on a charge of possession of a controlled substance. There's no bond authorized on that capias, and I'll appoint the public defender's office to represent you. Good luck, sir. Oh, wait, you have Ms. Leslie Sweet as your attorney?
Yeah.
Okay, then I'm not going to appoint the public defender's office at this time. Please tell me your name.
Donna Harvey.
You mess up.
21 CF 6777, you're here charged with possession of a controlled substance without a valid prescription, petty theft, 2 or more prior convictions, and possession of drug paraphernalia. There is probable cause. I'll appoint the public defender's office to represent you. I'll stay your bond at $2,500 on count 1, $1,000 on count 2, but I'll reduce count 3 to $100. You're not allowed to return to Winn-Dixie, located at 1565 West Orange Blossom Trail. Do you understand?
Yes, ma'am.
You're not allowed to possess or consume any controlled substance without a valid prescription. You're not allowed to have contact with any known drug dealers. And I'm revoking your out on bond case at this time.
My bond's still revoked.
It's revoked in your out on bond case. So you have bond in the new case, but not the old one.
So I can't go home.
Correct. Good luck. Yes.
I have court in 2 days. I'm supposed to have court downtown Orlando. I'm not going to that.
You can. They can transport now.
Okay.
So you'll either be transported or they'll do it virtually here in the jail.
Because it's for this bond that y'all revoke, I go to court for that in 2 days.
Well, then that judge can reinstate it if they're so inclined.
Okay. Thank you, ma'am.
Absolutely. Good luck. All right. I am. And I understand Mr. Bigney is dialed in.
Welcome to an Econo meeting. You are entering the meeting now.
Mr. Bigney, can you hear me?
I can. Can you hear me okay?
Yes, sir, I can. We are back on the record with your client, Jared Shelley, 19 CF 17133. I received the information. I have to tell you, I'm very intrigued by this program. However, unfortunately, I have to also tell you that I was able to get into contact with Judge Roach, and she did not want this court to grant bond. She requested that I hold your client at no bond until you can make the argument in front of her.
And I understand, and thank you for looking into that for us. And I'll get a hearing scheduled for Mr. Shelley with Judge Roach as soon as possible. But I thank you and everybody involved for at least giving us that fair shake.
Absolutely, and just so that you know, Mr. Shelley and also Mr. Bigney, I did communicate to Judge Roach that you had some very convincing arguments for bond. So, good luck.
Thank you so much.
Have a nice day.
Any action
You too.
on the out on
No,
bond?
I'm taking no action on that. Judge Roach can.
Stephanie Jones is mental health, Your Honor.
21 CF 6756, criminal mischief and battery. I'll appoint the public defender's office.
I'll waive, Your Honor.
All right, there's probable cause. I'll stay the bonds at 1,500. No contact, not return, no weapons, firearms or ammunition. Any other conditions the state would request?
No, Your Honor.
Please tell me your name. A warrant was issued for your arrest in 21 CF 4488, charging you with lewd or lascivious exhibition, attempted lewd or lascivious battery, and extortion. Another judge has already found probable cause in this
Your Honor,
case.
we have actually filed an information in this case already.
I see. What are the charges?
Count 1 is extortion, an F2. Count 2 is solicitation of a minor via a computer, an F3. And count 3 is lewd exhibition via a computer, an F2.
All right, I'll appoint the public defender's office to represent you. Does the state wish to be heard as to bond?
Your Honor, he has a pretty lengthy history of violent offenses, including one as recently as 2020. I believe he was on probation out of Hillsborough and has since violated that probation. He's also a violent felony offender of special concern. Given the nature of these offenses and the allegations within that warrant, including some of the messages that were sent to the victim, state would ask for a reasonable bond, given that these are F2s, 2 F2s and an F3, and that he has a rather lengthy violent history.
Ms. George, did you wish to be heard?
Your Honor, I would just point to the fact that he has no failures to appear and is employed full-time.
Your Honor, the defendant knew where the victim lived, her name, her mother's name, and other intimate facts about her, and I believe made statements partially to the effect of, don't let me catch you out, or something along those lines. The state would just ask for a reasonable bond, given, I believe the actual line was, you will see, don't get caught outside, just letting you know. And after giving intimate facts about her personal life, her mother, her name, state would ask for a reasonable bond, given his potentially dangerous nature to the community.
Can you read me count 1 in your information?
Yes. Count 1 is, I'm sorry, I just printed the front page so I could read off. So count 1 is extortion, which is an F2. The information reads, State Attorney charges Andre Maurice Lewis on or about the January 20th, 2021, in violation of 83605, verbally or by written or printed communication, maliciously threatened to expose Aaliyah Richardson, the victim, to disgrace or to expose any secret affecting Aaliyah Richardson with intent to compel Aaliyah Richardson or any other person to do any act or refrain from doing any act against the will of Aaliyah Richardson. In this case, it was, I believe, these sexually explicit videos. At the time, I believe she was 12, if I'm remembering correctly.
Thank you. Your bond will be $50,000 on count 1, $10,000 on count 2, and $10,000 on count 3. You're not allowed to have any contact with the victim or her family members. Do you understand what no contact means? I can't hear you. You have to get closer to the microphone. You're not allowed to have any contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to be within 1,000 feet of the victim's home, her residence, or where she goes to school. Do you understand that?
Yes, ma'am.
Are there any other conditions the state would request?
No weapons, Your Honor. Oh, you got that, never mind. No, you
I
don't.
did.
That's it.
Hold on a minute. What's he on probation for?
Written threats to kill or injure, 4 counts out of Hillsborough. He's already been held, I believe, on that VOP.
At no bond?
I believe he has a detainer, Your Honor. I don't think it's been an on view yet.
Yes, there's a hold, which was a warrant from Hillsborough County for the VOP. So they just have to serve it on him.
All right. All right, thank you. I show him as a violent felony offender of special concern and currently on probation, so I'm done. Please tell me your name.
Ensign Lloyd.
21 CT 971, you're here charged with driving while license suspended. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $500. You can't drive without a valid Florida license. You understand that?
Yes, ma'am.
In 21 CF 6779, you're charged with possession of cannabis greater than 20 grams and possession of drug paraphernalia. There's probable cause for this arrest as well, and I'll appoint the public defender's office to represent you. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You can't have contact with any known drug dealers.
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
Ms. George, I assume you want to be heard as to his out on bond case?
Yes, Your Honor. I would just point to the fact that it looks like his last conviction for resisting without violence was in 2017. He has 0 failures to appear. The charges that he picked up were nonviolent offenses, Your Honor. So I just ask that you take that into consideration and the fact that he is currently employed full-time. He has a child at home with cerebral palsy who he helps provide for. And he's been in the Orlando area for over a year. It looks like the out on bond case was from 2019, so I just ask that you take all of that into consideration and not revoke his out on bond. If you are inclined to revoke, I would just private attorney for that case, Your Honor.
What says the state?
He does have a private attorney for that case, Ms. Gilliard. State would ask that you revoke. He was out on bond for firearm and drug offenses, and he picked up additional drug offenses, and drove on a suspended license, which I believe was an 893 suspension. In regards to the 2019 case, I understand counsel's argument that it is a 2019 case. That case was sent to PTD and he got rejected by not showing up to the contract signing, just showing an inability to comply with the state trying to provide resources. So state would ask that you revoke. If you're not inclined to outright revoke, state would ask that you at least revoke and double.
At this time, I'm revoking your bond. Your attorney will have to file a motion in front of the trial judge. Good luck, sir. Y'all, it's hot. Please tell me your name.
What was that? Oh, Javon. My name is Javon Mason.
All right, you're here in 21 CF 6794, charged with grand theft of a motor vehicle and burglary of a conveyance. I'll appoint the public defender's office to represent you. There is probable cause in this case. I'll stay your bond at $3,500.
All righty, and I'm representing myself in this case.
Okay. Hold on, let me get back to that in one moment, okay?
Absolutely.
I think the bond should be on the burglary. The $3,500 should be on the burglary and $150 on the grand theft. So that would be count 2. So, sir, you don't want me to appoint the public defender's office to represent you?
No, ma'am.
All right.
There's no way we can sign a stay at $3,500 total, please?
It's $3,500 and then $150 for the other count. So it's $3,650 is your total bond. You're not allowed to have any contact with the victim or any witness in this case. You're not allowed to return to this scene. You're not allowed to possess a weapon of any kind, firearm or ammunition.
And, Your Honor.
Sir, hold on one second, counselor.
Okay.
You're also out on bond for a grand theft of a motor vehicle, and at this time, I'm going to revoke that bond. So you're going to be held at no bond. Do you understand that?
And because of that, Your Honor, I would ask that you appoint, I don't know if we've already been appointed on that, but that you appoint us. He's gonna be held at no bond. He can't file any.
He has a public defender representing him on that case.
Okay, thank you.
Does that mean? What's that one? Okay, well, let's put that one over there on her. Hold on one second. I don't want to mess the record up. We're gonna.
Yes, Your Honor, there is a PD on the 5761.
Okay, I just wanted to make sure there is.
And I'll move this one back. That's okay. Right, I'm gonna move this one and then roll over that court. This one. That struggle's real. All right, Mr. Mason. You understand that while you were out on bond for a grand theft charge, you were arrested for a new grand theft charge. And at this time, the court is revoking your bond on the other grand theft. Do you understand that?
I understand.
All right.
I understand.
And you still don't want an attorney to represent you on your new case?
Oh, ma'am.
You understand that the state is represented by attorneys who went to law school and who are experienced and who know how to practice law, right?
Absolutely.
Did you go to law school, sir?
No, I didn't.
All right. What's the highest level of education that you have?
12.
You graduated from high school. So you understand that You're at a disadvantage if you represent yourself because you're going up against someone who has a law degree and experience practicing law.
I don't believe in a disadvantage, ma'am, but I understand you. Absolutely.
Okay, so you don't think you're at a disadvantage?
No.
All right, then at this time, I'm not going to appoint the public defender in your new case, but they've already been appointed in the old case, okay? So you're gonna have to take that up with your trial judge. And that's what you want, right?
I'm sorry?
That's what you want me to do, right?
Again, yes, I'm representing myself in this case.
All right, good luck, sir.
What's the court date on that case, though?
I don't have those court dates, that's for the trial judge, but your attorney will have those.
All right, thank you.
Good luck, sir. Please tell me your name.
Devins Morgan.
A warrant was issued for your arrest in 21 CF 6576, charging you with 4 counts of attempted first-degree murder with a firearm, discharge, attempted felony murder with a firearm, conspiracy to commit first-degree murder, attempted felony murder, principal in the first degree to attempted murder, shooting into an occupied vehicle, possession of a firearm by a convicted delinquent, and aggravated child abuse with a firearm. At this time, I'll appoint the Public Defender's Office to represent you. Another judge has already found probable cause in this case. Does the state wish to be heard?
Yes, Your Honor. As to bond for count 1, 2, 3, 4, 5, and 11, all are punishable by life or life offenses. They would ask that you hold him no bond pending an Arthur hearing and set reasonable bonds as to 6, 7, 8, 9, and 10.
Ms. George, did you wish to be heard?
No, Your Honor, we reserve the right to have Arthur here.
I do think that is wise. Because these charges are punishable by life offenses, at this time, I'm going to hold you at no bond. As to count 6, your bond will be $25,000. Count 7, your bond will be $25,000. Count 8, $25,000. And count 9, actually 9 and 10, also $25,000 on each. You're not allowed to have any contact with any victim, witness, or co-defendant in this case. You understand what no contact means? I can't hear you.
Or not supposed to be talking to them.
I can't hear you still.
He's not supposed to be talking to them.
Right, you can't have, but no contact means you can't speak to them, you can't call them on the phone, you can't send a message through a friend or family member. This is no contact at all, you understand that?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. Since several of them are no bond, are there any other conditions the state would request at this time?
No, Your Honor.
All right, good luck, sir.
And just to be clear, that was no bond on 1, 2, 3, 4, 5, and 11.
11,
and then
correct.
25,000 on the additional.
Yes.
Thank you.
In those cases, the jail will keep the co-defendants separate, right?
I'm not sure.
In cases like this, if co-defendants are incarcerated, the jail keeps them separated? Because if we're ordering no contact and then they end up in the same area. Okay. Okay. So I think there is a co-defendant in this case that I'll also see later today. Do I need to do anything else to make that clear so that they keep them separate? Okay, I just want to be sure. Please tell me your name. What's your name?
Christopher New.
Thank you, sorry, I couldn't hear you. You have a warrant out of Palm Beach in 199031 for violating probation. There's no bond authorized, and I'll appoint the Public Defender's Office to represent you. We'll notify them that you're here so that they can transport you for that case. But you also have 21 CF 6788, a driving while license suspended charge here. There is probable cause, and I'll appoint the Public Defender's Office to represent you. I'll stay your bond at $2,500. You know you can't drive without a valid license, right?
Yeah, he already.
Okay, I'm not you don't have to explain anything, I just want to make sure you know that.
I was trying to say he already bonded on that.
Oh, he did? Oh,
On the driving case.
okay. Good. All right. I just want to be sure you know. Okay. Good luck. No. No. I didn't realize that. Please tell me your name.
Rashad Pilgrim.
21 CF 6793. You're here charged with possession of a concealed weapon or firearm by a convicted felon, possession of ammunition by a convicted felon, and possession of cannabis greater than 20 grams. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond on count 1 is $10,000, count 2, $4,000, count 3, $150. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
4,000. Good luck, sir. I have he's on federal probation. I don't know if that, good luck. Please tell me your name.
Darius Plummer.
You have an out-of-county warrant out of Lake County in 18 CF 624 for failure to appear on a charge of driving while license suspended. There's no bond authorized, and we'll notify them that you're here. You also have 21 CF 6786, driving while license suspended. There is probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Your bond is $2,500. You can't drive without a valid Florida license. You understand?
Yes, ma'am.
Okay, good luck. Dexter, this next one is the co-defendant. Please tell me your name.
Freddie Reed.
21 CF 6577. A warrant was issued for your arrest, charging you with 4 counts of attempted first-degree murder with a firearm, attempted felony murder with a firearm, conspiracy to commit first-degree murder, bodily injury by another during a felony, principal in the first degree to attempted murder, shooting or throwing a missile into an occupied vehicle, possession of firearm by a convicted felon, and aggravated child abuse with a firearm. Another judge has already found probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Ms. May, did you wish to be heard?
Yes, Your Honor. As to count 1, 2, 3, 4, 5, and 11, they are punishable by life offenses. State asks that you hold him no bond pending an Arthur hearing and set reasonable bonds as to 6, 7, 8, 9, and 10.
Ms. George, did you wish to be heard on that?
No, Your Honor, we reserve the right to have an Arthur hearing.
All right, at this time, because counts 1 through 5 and 11 are punishable by life offenses, I'm going to hold you at no bond on those charges. However, counts 6, no, is it count 5?
No, 6, 7, 8, 9, and 10.
6, 7, 8, 9, and 10. On each of those charges, your bond will be $25,000. You're not allowed to have contact with any victim, witness, or co-defendant in this case. Do you understand what that means?
Yes, ma'am.
Even while in custody, you can't have any contact.
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. And I'll leave the rest of the conditions up to the trial judge when you have the hearing. Good luck. Bonded. Please tell me your name.
My name is Richard Rivera Pagan.
21 CF 6792. You're here charged with possession of fentanyl, possession of drug paraphernalia, and disorderly conduct. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond is $5,000 on count 1 and $100 on counts 2 and 3 each. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yeah, I understand.
Man, what should I do? Because I mean,
Hold on, get closer to the mic so I can hear you.
It was empty baggies.
I wouldn't talk about the facts.
It was empty baggies that I had.
Okay, so hold on.
It was supposedly it was a possession, and the paraphernalia. I mean, they didn't even test it out or nothing. So I accept disorderly conduct, but the other ones, I mean, I don't know if they could do some type of thing, because I mean, there was empty baggies that I had. I got like all the possessions in my record, they're all empty baggies, and I don't understand why they keep on going forward with that.
All right, so at this time, what we're doing at this hearing today is I reviewed the probable cause affidavit. There is probable cause for your arrest. That does not mean the state is going to file the charges as you were arrested or that they can sustain a conviction at jury trial. We're just establishing probable cause, and I'm giving you bond conditions.
Okay.
And I want to make sure that you understand that everything you say in this hearing is being recorded and can be used against you later. You understand that?
But is there another bond hearing I can go to? Because I mean, I don't have really any money. So-
Yes, your attorney can file a bond motion in front of the trial judge who's hearing your case.
Your Honor.
You also, let me get there. Thank you. You were also out on bond in 21 CF 4796. Actually, you were released on your own recognizance on charges of possession of methamphetamine, cocaine, and drug paraphernalia. At this time, I'm inclined to revoke that. Let me ask Ms. George if she has any argument as to why this court should not revoke that bond.
Your Honor, I would just argue that he was just released on that charge for a notice of non-filing. A notice of non-filing. So I just ask that you not revoke, as well as the fact that we are having him evaluated.
I'm sorry, you were what?
Having him evaluated, Your Honor.
Counselor, his last conviction was in March of this year, and it was a burglary charge in addition to drugs.
No, I understand, Your Honor.
Hold on one second. Okay, thanks. March, Counselor.
Your Honor, that was partially my argument. He just pled to something in March, including drugs. He has a significant history, significant failure to appear history. We did ROR him from a notice of non-filing on this case May 29th, due to FDLE not coming back in time before that 33-day motion. It was a methamphetamine, cocaine, and drug paraphernalia. And in a week, 2 weeks, he picked up additional drug charges. State would ask that you revoke. If you're not inclined to revoke, state would ask that you revoke and double.
I'm going to revoke it at this time. Your attorney's going to have to file a motion in front of the trial judge, sir. Good luck.
What they do, I mean, if they drop the charges, that's 33.
You'd be released if they drop the charges, yes.
But I dropped the charges. That was what happened to the other one. They dropped it, right?
I don't know about that, but not the case for which you're out on bond.
They're
No,
not
they
gonna go along
didn't,
with
they
the.
didn't drop it, they just did not file, they have not filed an
Yeah,
application.
can you please understand? I mean, that they dropped that charge. I mean, I don't know if you guys
He's-
don't pick it back
He's
up.
confused.
They didn't drop it, sir? So your attorney's going to have to,
Deal with both of them now.
correct,
Deal.
correct. Your attorney can file a motion in front of the trial judge.
All right, I guess I'll.
Good luck, sir. Bonded. Please tell me your name.
Luis Orlando Suarez Jr.
I'm sorry, one more time?
Luis Orlando Suarez Jr.
Hold on. Oh, I'm sorry. 21 CF 6803. You're here charged with fleeing or attempting to elude with lights and sirens activated and reckless driving. A warrant was issued for your arrest, so another judge has already found probable cause. I'll appoint the Public Defender's Office to represent you. Let me review this really quickly to get I didn't have this before court, or I got it right before court. And I don't have a face sheet.
For Louise,
I'm sorry?
this defendant?
I don't have anything. I have the warrant. I'm reviewing the affidavit right now. I'll set your bond at $10,000 on count one, $100 on count two. Are there any conditions the state, any special conditions the state would request in this case?
No, Your Honor.
All right, good luck, sir.
Are you appointing the PD?
I did. Sorry, I forgot you did hand me that report. And I just got the other one too. Please tell me your name.
James Wood.
Get closer.
James Wood.
All right, you're here in 21 CF 6775, charged with burglary of a structure with assault or battery and petty theft. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. What says the state has to bond on count one?
Your Honor, as to count one being a punishable life offense, they would ask that you hold him no bond. I understand that the affidavit is rather limited. I believe there are supplement reports. I believe one is referenced. However, in the affidavit, it does indicate that the victim was battered when she confronted Mr. Wood in the hotel in a place that he was not allowed to be. So I do believe there's PC for that charge, and you can hold him no bond. However, you're not inclined to hold him no bond. State would ask for a 24-hour reset in the alternative.
Ms. George, did you wish to be heard?
Your Honor, I had the same issue as far as the limited facts in the arrest affidavit, but it seems that in the bottom it did mention that he was in the, I guess the room where the employees have their lockers, so.
A place not open to the public, Your Honor?
Correct. So-
Wait, I couldn't hear that. What'd you say, Ms. May?
A place not open to the public.
Great.
Correct. So I was not making a PC challenge, and Your Honor, we just reserve the right to have an Arthur hearing. I mean, he's already out on a petty theft, which I anticipated being revoked as well, Your Honor.
Yes, I appreciate that, and I did have the same questions that both of you raised. I do think there's probable cause, because at the end where it explains that, there's probable cause for the charge. However, I just want to give you the opportunity to be heard and then let me know if there's anything I was missing. Sir, did you want to ask a question or say something?
Yes, I understand you, I'm trying to get a bond on this because, you said what?
I understand. Listen, everything you say here is being recorded and can be used against you later. All right, at this time, I'm going to hold you at no bond on count one, stay the bond at $100 on count two. Even while in custody, you're not allowed to have any contact with the victims and witness in this case. Do you understand?
Yes.
All right, I'm going to revoke your bond in 20 CF 9099. While out on bond for a theft charge, you were arrested for another theft charge, but with heightened violence. So your attorney is going to have to file a motion in front of the trial judge to get bond in both of those. I show that he's on probation and that he's a violent felony offender of special concern.
Yes,
You
Your
said
Honor.
a violent felony offender.
Get closer, I couldn't hear you.
He said a violent felony offender.
What is that?
Didn't know what a violent
I
felony.
never had any
That's
violent,
what you're classified on the DOC.
you say what?
That's what you're classified as.
Violent offender?
A violent felony offender of special concern is a designation.
I never had any violent charges other than,
Talk to your attorney about it.
All right, so I got one more question, Judge.
Yes, sir.
All right, so she was just saying something about, this is all crazy, because
I advise not to talk about the facts of
I
the
don't
case.
really care. Because I'm not talking about any facts. It's just, on this stuff, where am I getting petty theft? Where you see probable cause for petty theft, for one? Like, I never even, I'm just gonna leave it like that. It's no probable cause for petty theft, even with references of the cases and stuff like that. And I understand it is a concern that I'm not on bond already for petty theft, but it's no probable cause for any petty theft, just like a lot of this case.
Ms. May, could you please put the factual basis on the record?
Yes, Your Honor. On or about June 8th of 2021, law enforcement arrived to the Hilton Garden Inn in regard to a robbery. A black male pushed past the manager of the Hilton Garden Inn and ran off the property. A witness advised that he observed the suspect enter the Lynx bus. Law enforcement made contact with the male at the Lynx bus stop, who matched the description of the male at the Hilton Garden Inn. The male was secured in handcuffs and identified as Mr. Wood. A black handle with a red frame bolt cutter was on the floor where Mr. Wood had been sitting. A show was conducted by deputies with the hotel employees who had burglarized the lockers and battered an employee. The ID was confirmed as the same male from the Hilton Garden Inn.
My question is, what was stolen?
A Bank of America debit card with the name Dana Adrian Malcolm was recovered from Mr. Wood's backpack and placed into evidence. His backpack contained miscellaneous items along with a red and blue windbreaker jacket, and the backpack was placed in evidence for safekeeping.
Again,
Victim Natalie Mower had been battered when she confronted Mr. Wood in the hotel. He was in an area where he did not have the right to be, and he was possibly identified by the victim and had the bolt cutters. All events occurred in Orange County, Florida.
Again, what was stolen? Everything in that backpack they took evidence pictures of belonged to me.
The debit card of Dana Adrian Malcolm.
And also excuse me, sir, also 2 backpacks were stolen out of the employee locker room area.
That was not on me, in my possession. That was not stolen. They just saying that is stolen. Again, where does that petty theft fall?
Sir, the probable, there's cause to believe that you probably stole the backpacks. That's what probable cause means. Now, whether the state decides to charge that, I don't know, and they'll have to prove that at a jury trial beyond all reasonable doubt, but that's not where we are today. Today, the standard is probable cause, and based on what I read in that affidavit, there is probable cause to believe that you stole those backpacks and then discarded them. So, I've already found probable cause in this case. You're gonna have to talk to your attorney about any defenses you think you may have. Good luck. Please tell me your name. A warrant was issued for your arrest in 20 CF 6899, charging you with conspiracy to traffic in fentanyl 28 grams or more, 2 charges of that, conspiracy to traffic in cocaine 400 grams or more, 2 counts of that, racketeering, conspiracy to commit racketeering, and then 4 counts of conspiracy to commit unlawful transportation of U.S. currency, unlawful transportation of U.S. currency, 2 counts of that, so 12 counts altogether. Another judge has already found probable cause for your arrest, and I'll appoint the public defender's office to represent you. At this time, I will stay the bonds as listed in the warrant. $500,000 on count 1, $250,000 on counts 2 and 3, $100,000 on 4 and 5, $50,000 on count 6, $25,000 on counts 7, 8, 9, and 10, and $1,000 on counts 11 and 12. You're not allowed to have contact with any victim or witness in this case. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand? You're not allowed to have contact with any known drug dealers or possess a weapon of any kind, firearm, or ammunition.
Your Honor, the state would request that he also comply with 903.046 sub 2 sub F if he were to procure those bond funds, just giving an affidavit to the court showing that the funds did not come from these illegal activities.
All right, what says the defense?
No argument, Your Honor.
All right, I will order that.
903.046, sub 2, sub F.
Thank you. Good luck, sir. What happened with Clifford White? Please tell me your name.
Kyle Gregory Barkowski.
20 CF 4288. You're here because a warrant was issued for your arrest for violating your community control by failing to remain confined to your residence except for 1/2 hour before and after approved employment, public service work, or any other special activities approved by your probation officer. There's no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Hold on one second. Oh, hold on, wait, before you take him out. Also, so I show that you're a sex offender or a sexual predator. So you understand that you'll have to comply with all your sex offender reporting requirements, right?
Those were charged for ground to a,
Okay, hold on. I don't know if that's true, but if you are a sex offender, you have to comply. Do you understand? Okay, good luck. Please tell me your name.
Jonathan Reynaldo Diaz.
A warrant was issued for your arrest in 17 CF 4757 for violating your probation by committing the offense of driving while license suspended on or about April 14th, 2021. For being arrested for committing the criminal offense of assault, aggravated assault with a deadly weapon on May 22nd, 21 in Osceola County, and the criminal offense of battery also on that same day in Osceola County. There's no bond authorized on this warrant, and I'll appoint the Public Defender's Office to represent you. Yes, sir.
I have a lawyer fighting both of these cases.
Okay.
I've been put on bond for all of these cases already, and then I just got picked up by my probation office yesterday for my second VOP on the battery charge. I was just really hoping that you can honor the 3 bonds that I've already paid in Osceola County so that I could get back to providing for my wife. She's very sick. She has lupus, and I'm the only sole provider for her. We have 3 kids, and the second charge is with my boss, and he wants to come to court and, tell him that he wants me to continue to work for him.
He's going to have to do that with the trial court, sir, and I'm sorry to hear about your wife, but at this time, I am not going to change another judge's warrant, so you'll be held at no bond. Now, is your attorney someone that you hired that's not a public defender?
Yes.
Okay, then I'm not going to appoint the Public Defender's Office to represent you, and your attorney can continue to represent you.
I have to pay him, though.
Okay, so do you want me to appoint the Public Defender's Office?
Well, yes, because I'm not going to be released to pay him.
All right, I'll appoint the Public Defender's Office to represent you. Good luck, sir.
Appreciate it.
Please tell me your name.
Denise Jenkins.
A warrant was issued for your arrest in 20 CF 11941 for violating your community control by failing to remain confined at your approved residence except for 1/2 hour before or after approved absences. There's no bond authorized on that warrant, and I'll appoint the Public Defender's Office to represent you.
Yes, ma'am.
Good luck.
Your Honor, I also have a VOP. Is she not being seen on that today?
Oh, bring her back. Hold on. I missed it. Oh, I see it. I'm sorry, Ms. Jenkins. You also have a violation of probation. Thank you, Ms. May, for catching that. In 19 CF 13376. Wait. Is that the right case number? Okay. There is also no bond on that, and I'll appoint the Public Defender's Office to represent you on that one as well.
Rank concurrent together.
All right. Good luck, ma'am. Please tell me your name.
Jeremiah Nelson.
20 CF 10065. A warrant was issued for your arrest for violating your community control by failing to remain confined to your approved residence as directed by your probation officer on or about May 12th and also May 28th There's no bond authorized on that warrant, and I'll appoint the Public Defender's Office to represent you. Good luck. Please tell me your name.
Brandon Rentes.
21 CF 6746. You're here charged with fleeing or attempting to elude law enforcement at a high rate of speed and driving while license suspended as a habitual offender. There is probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Ms. May, can you tell me what the speed was? I just see high rate of speed.
I just see high rate of speed, Your Honor, but I would also point to that he was driving without lights at 11:41 p.m.
And on East Michigan Street, which is a small street, it's not a highway. Hold on, let me see. All right, at this time, your bond will be $10,000 on count one, $2,500 on count two. You cannot drive without a valid license, you understand that? And then in 20 CF 5720, you're here for a violation of probation. There's no bond, and I'll appoint the Public Defender's Office to represent you in that as well. Good luck, sir. Please tell me your name.
Terrell Smith.
A warrant was issued for your arrest in 19 CF 17160 for testing positive for marijuana on May 4th and on May 13th. And by associating with persons engaged in criminal activity and by failing to remain confined to your approved residence except when authorized. There's no bond on this warrant, and I'll appoint the Public Defender's Office to represent you. Good luck, sir.
Can I speak?
You can. Everything you say is being recorded and can be used against you later.
No problem. I just wanted to speak up because I only felt one drug test. And I heard you mention I felt two.
That's what's in the warrant.
I know that's incorrect. I only felt one. I now have my medical marijuana card because of this situation, and I also have mental disorders, and that's why I use marijuana. My probation officer was aware. I told him that I would fail my drug test, and he drug tested me anyway. He gave me 30 days to try to clean my system, which he did not even drug test me. Again, he just, I believe, put out a warrant that I did not know about. I never knew I violated until yesterday morning, and I checked in. I got arrested in my school uniform. I was supposed to go to school tomorrow. I'm in college. I graduated once. I'm finna graduate again. And I just feel like it wasn't fair. There's nothing I could do. I can't ask for a new probation officer. There's nothing I could do. There's this guy, he's gunning at me, basically. And
Sir, the affidavit says that you failed, even if you only failed one drug test, you can't take any controlled substance without a valid prescription while on probation, and the allegation is that you did. So you're gonna have to present those defenses to your defense attorney, who can then present them to the trial judge. But I'm not going to change that warrant today.
All right, thank you.
Yes, sir, good luck. Please tell me your name.
Al-Mustafa Darouche.
You have a warrant out of Osceola County in 21 CF 874 for violating your probation on a charge of criminal mischief. There's no bond authorized. I'll appoint the Public Defender's Office and will notify them that you're here so they can transport you. Good luck, sir. All right, so the only one I have left is Mr. Marrero Figueroa.
I have Minnick.
Oh, wait, it was attached. Hold on. Please tell me your name.
Joshua Minnick.
21 CF 147, a warrant was issued for your arrest out of Nassau County for failing to appear on a charge of possession of a weapon or ammunition by a convicted felon and discharging a weapon in public. There's no bond authorized. I'll appoint the public defender's office and we'll notify them that you're here. Good luck.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter, previously sworn.
Please connect to the headset and advise if he can understand you.
Sí.
We're connected, Your Honor.
All right, sir, please tell me your name one more time.
Carmelo Marrero Figueroa.
Carmelo Marrero Figueroa.
21. I gotta find the case number, hold on. 21 CF 6802. Sir, I know you were here earlier. I had to get the affidavit for the warrant that was issued for your arrest. I now have that affidavit, and I had the opportunity to review it. I've previously appointed the public defender's office to represent you. At this time, Counselor, I know that you made the argument for pretrial release, but after reading the affidavit, have you seen it? Oh, no, I'm the only one who has a copy of it.
Right, I couldn't.
He wasn't just driving fast. Hold on one second. Let me see if I can find it again. He was driving fast, intentionally, like saw the law enforcement officer several times, looked back, fled at a very high rate of speed. He was also popping wheelies on the road.
I understand, Your Honor.
This is a pretty dangerous situation. One of the purposes of bond is to secure the safety of the residents of Orange County.
Your Honor, I would just ask that if you are not inclined to put him on pretrial release, that you would at least lower the bond amount and place him on pretrial release. That way, it'll be a condition that if he violates, he'll be brought back here, and he'll also be monitored, Your Honor.
So here's another question, Ms. George. Part of the allegation in the affidavit is that your client participates in street racing. What reasonable conditions of bond can this court place on your client that will prevent him from participating in street racing, which is incredibly dangerous for our fellow citizens?
Your Honor, again, I would just point to if you place him on pretrial release in conjunction with the bond.
Your Honor, I'm sorry, but the interpreter's having a very difficult time hearing counsel.
All right,
So-
she's getting closer.
If you place him on pretrial release in conjunction with a bond, Your Honor, if he does violate, he'll be brought back here. Even if you give him a bond, he can still violate. But I think that if you place him on pretrial release, he's monitored as well as having to post that monetary bond.
All right, at this time, I am going to place you on pretrial release and require that you post a monetary bond. However, based on the arguments of the attorneys, I will reduce the amount of that monetary bond to $7,500. I don't know exactly how this will be enforced, but I'm ordering that you are not allowed to participate in any street racing. Do you understand? You have to answer out loud.
Yes. Yes.
Did we ever, oh, you don't have this, hold on. I don't think we know. I don't. You're not allowed to have any contact with any witness in this case other than your wife. You can have contact with your wife. But any of the other motorcycle drivers, you can't have contact with them. Do you understand?
Okay.
All right. Good luck, sir.
Thank you.
Thank you, Mr. Interpreter. I think that's all we have for you today.
You're welcome, Your Honor. Thank you.
Any other business before court is adjourned for the day?
No, Your Honor.
Court is adjourned.
No, I said no.